supported by the Philippine Judicial Academy, the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Association of Law Schools, and the Philippine Society of International Law. This is the 5th time that we are doing this symposium on public international law. The first time we did it was in December 2020. We did it online only for the past 4 times, and for the first time, we're doing it in person here in UP BGC. The aim of the symposium is to present case studies which show how international law, as well as ASEAN law, which is a kind of international law, can be applied in Philippine cases before Philippine courts and executive agencies, to be decided by Philippine judges and Philippine executive officers. This session, this edition of the symposium is special because not only do we have J.D. students from UP, we also have our UP LL.M students who are here with us this afternoon, as well as our LEAP Fellows. The LEAP Fellows are law teachers who enrolled in the fellowship course for effective teaching methods of international law. So yesterday we had our LEAP Fellows, and also we had about 50 J.D. students. This afternoon, we will have the presentations by 25 UP LL.M students. Many of them judges, prosecutors, government lawyers, and also court attorneys, and as well as private law practitioners. Okay? So our first presenter is the beadle of the class in the course ASEAN Law. I now invite Attorney Chris Erwin Alquizalas for his presentation.
Good afternoon, classmates. So once again, I'm Chris Erwin Alquizalas, and my topic involves the ASEAN Comprehensive Investment Agreement and in the special field of commercial law. So here, I explore the option of a possible remedy for a non-Philippine ASEAN corporation who is not registered to do business in the Philippines to sue in a Philippine court. So the specific scenario is as follows. Thai Elephant Inc. is a corporation registered and based under the laws of Thailand, an ASEAN member state. It recently launched a social media platform called Elephant to rival existing social media sites, particularly Twitter. The platform allows users to post their thoughts, ideas, short articles, artwork, and any other content for other users to see. To sign up, users can join for free with an option to avail of Elephant Gray, where users' posts can be boosted and gain access to other special features within the app. Due to its rising popularity, the platform gained users from around the ASEAN, including the Philippines. Likewise, the rising approval of this site generated interest from several advertisers, which resulted in advertising contracts between them. However, being in its relative infancy, it is not immune to problems such as scams and even the advertisers not following through with their contracts. As a result, with the goal to protect the corporation, it now seeks to file a claim for them, a claim under the Philippine court. So under the current Philippine legal landscape, to recall, a foreign corporation can sue under 2 instances. First, under the revised corporation code, it can sue if it is registered in Philippine law and it is issued a license to transact the business. And secondly, under the revised corporation code, it also states that no foreign corporation can operate a business and even intervene in any suit unless it is registered in the Philippines. So the second exception to this, the second consideration for a corporation to sue in the Philippine jurisdiction is that under jurisprudence, a foreign corporation has personality if the action involves only an isolated or casual transaction, or if it's based on a cause of action entirely different of any independent business transaction. So under any circumstances not provided for those 2 instances, then a foreign corporation cannot bring action under Philippine law. So it is submitted here now that by virtue of the AKIA, which is specifically Article 5 thereof, that a non-Philippine ASEAN corporation may be allowed to sue in a Philippine court. So particularly since in the Article 5 of AKIA, it provides that there should be treatment no less favorable than it accords in like circumstances to its own investors. I argue that the foreign corporation here registered in its own member state, in its home country, should be allowed the same remedy, which is afforded to local corporations, which is also to sue. So from the foregoing then, that should be the additional exception and the remedy for for the ASEAN member corporation. So is this rule binding, as we have discussed before in class? The AKIA was domesticated and it was signed and ratified by the President in 2009. However, as there is no Senate concurrence, then it only falls into the third tier of Philippine law, which is the same as an executive regulation, a procedural rule, or a local ordinance. So again, to recap, the conclusion that I aim to forward is that for a non-Philippine ASEAN corporation who wishes to sue in the Philippines but does not have a license, I argue that by virtue of the AKIA, then it may be allowed as an exception to sue even if it doesn't have a license. So there. So up next, I would like to introduce our next speaker, which would be Attorney Siti Yasmin Agwang.
Good afternoon, Prof. Raj and classmates. Assalamualaikum. In the Philippines, there are about 100 million Facebook users, or about 88% of the population. This is the reason why Meta Platforms, corporations, Facebook Marketplace is one of the famous e-commerce sites in the country because of its wide consumer coverage. As you are aware that this commercial platform makes its users advertise and connect with potential customers conveniently, this technological advancement comes or becomes a haven for online fraudsters. And I happen to have a friend who is a victim of this. As a government employee living in the countryside with less access to physical shops, she ordered a laptop from one Facebook Marketplace online seller intended for the online class of her son. She paid the item in full, around, I think, 40,000 pesos, plus the shipping fee. Unfortunately, the item delivered to her was a Leapfrog laptop toy. She tried to contact the seller, but to no avail, as she has been seemingly blocked by the seller. My friend is just one of the many victims of these bogus sellers on Facebook Marketplace. And this is the problem I wish to seek relief for in this case study. One of the factors of these scams is the lack of regulation by Meta Platforms Corporation, particularly its Know Your Client component. Anyone can advertise and sell everything, whether legitimate or not. Although the Philippine rule, particularly RA 7394 or the Consumer Act of the Philippines, Article 60 provides penalties for violation of Article 50, which is the prohibition against deceptive sales, acts, or practices by a seller or supplier in connection with a consumer transaction violating this act, whether it occurs before, during, or after the transaction. This law is rather punitive in character, which occurs after the damage has been done and requires procedural matters. By the reading of the law, it implies its applicability to physical shops. It does not address this issue on the alarming number of bogus Facebook Marketplace online sellers. In addition, the IRR of the E-Commerce Act only provides matters of protection for privacy and confidentiality of the consumers. However, if we look into the international plane, particularly in the ASEAN region, we can apply the ASEAN Agreement on Electronic Commerce, or AAEC, which has been ratified by President Duterte on November 18, 2020, and has a binding effect of an executive agreement to supplement regulation on online selling. AAEC provides that the application of the measures to be adopted or maintained by its member states pertaining to e-commerce, particularly on the provisions found in Article 7, Paragraph 3 Online Consumer Protection, which states that member states recognize the importance of adopting and maintaining transparent and effective consumer protection measures for e-commerce, as well as other measures conducive to the development of consumer confidence. For the avoidance of doubt, the government is doing its part. They are responding to those reports by the victims. This study aims to be proactive and preventive rather than reactive. The proposition to strengthen KYC measure for different levels of online transaction is a transparent measure to safeguard the interests of the consumers. Finally, as a binding executive agreement under Tier 3, applying the 7-step process, AAEC can now fill in the gap to compel Meta Platforms Corporation to provide for stringent measures in order that the confidence of the consumers be maintained in its platform, Facebook Marketplace. The stringent KYC measure will require a stricter guidelines for membership and online commercial posting, depending on the transaction involved. That ends my presentation. I now call on the next presenter, Fiscal Crystal de Imbido Benaventura.
Good afternoon, Sir Raj. Good afternoon, classmates. The problem, as indicated in my slide, is a non-Filipino ASEAN investor cannot register a commercial fishing vessel. With a particularity, the hypothetical problem is that Mr. B, a Singaporean national, engaged in fishing business in Rojas City, Capiz. And as an investor, he would like to register a commercial fishing vessel that will be used in their business. However, when he consulted a Philippine lawyer, he was advised that there is a prohibition for foreigners to register commercial fishing vessel and seek application before the Bureau of Fisheries and Aquatic Resources pursuant to Republic Act 8550 or the Philippine Fisheries Code. As such, he would like to invoke the benefits accorded to investors pursuant to the ASEAN Comprehensive Investment Agreements as basis to authorize him to register commercial fishing vessel. So, as applying the 7-step process, whether the AKIA is binding in the Philippines, yes, the answer, considering that it is a hard law, it is binding into the Philippines, and how is it transformed as a domestic law? Considering that despite the non-concurrence of the Senate, there is a ratification made by President Gloria Macapagal Arroyo on August 6, 2009, and the instrument of ratification was deposited on October 26, 2009. The Philippines followed the prescribed manner of expressing its consent to be bound by the AKIA through the signature of the President and the deposit of the instrument of ratification. Following the place in the hierarchy of Philippine legal rules, AKIA is in Tier 2 in the international legal system. As such, it is the same level as a statute. However, in this case, there is a conflict between the Section 27 of RA 8550, considering that there is a prohibition with regard to the registration of foreigners to register a commercial fishing vessel. As such, applying the sequential analysis and also applying the rule on statutory construction applicable to this case is lex posterior derogat priori, which means that a later law repeals an earlier law, considering that AKIA was a later law compared to the RA 8550, which was enacted on February 25, 1998. And applying in the Philippines, if we will use AKIA as a basis, we can now authorize nationals of ASEAN member states to register commercial fishing vessels. That ends my presentation. I'd like to present the next presenter, Attorney Mark Dale Peral.
Good day, Prof. Raj, classmates. My presentation deals with the right to private practice of profession, and the right to build and right to property. The problem in this case study is a non-Philippine ASEAN civil engineer cannot sign and seal building plans for a building permit. The factual antecedents of the case study are as follows. ABC Property Development Corporation, a Philippine corporation, will be constructing a 50-story building in Makati. In preparation of the development, they hired Engineer C, a Singaporean civil engineer, to conduct the structural design and analysis. Upon completion of the design, however, the building permit was disapproved by the city building official of Makati on the ground that the Singaporean civil engineer cannot sign and seal structural plans. The National Building Code of the Philippines, Presidential Decree number 1096, requires the approval of a building permit by the building official prior commencement of any construction activity. As a requirement for building permit, the National Building Code implementing rules and regulations sections 301 and 302 mandates that a civil engineer must sign and seal the structural plans. The building official argues that the Singaporean civil engineer, a non-Filipino civil engineer, cannot sign and seal the structural plans because Article 12, Section 14 of the Constitution provides that the practice of all professions in the Philippines shall be limited to Filipino citizens, save in cases prescribed by law. In addition, the PRC Modernization Act under Section 7J mandates that the requirements for the registration or licensing in Singapore must substantially be the same as those required and contemplated under the laws of the Philippines, and that the laws of Singapore should allow citizens of the Philippines to practice their profession on their soil. Finally, the Singaporean civil engineer must also comply with the requirements of the Philippine Civil Engineering Law, Republic Act number 544, sections 8, 12, and 13, which includes the passing of the Civil Engineering Board exam. Hence, according to the city building official, the denial of building permit is proper. The relief sought is to authorize non-Philippine ASEAN civil engineer to sign and seal building plans for a building permit. It is hereby submitted that the Singaporean civil engineer can sign and seal structural plans for building permit pursuant to the ASEAN Framework Agreement on Services, or AFAS. Under Article 5 thereof, it provides that each member state may recognize the education or experience obtained, requirements met, or licenses or certifications granted in another member state for purpose of licensing or certification of service suppliers. The Republic of the Philippines is bound by the AFAS because it is an international agreement that has been signed at Bangkok on December 15, 1995, ratified by then President Fidel V. Ramos on March 18, 1996, and entered into force on August 12, 1998. Clearly, the Republic of the Philippines expressed its consent to the framework agreement by way of transformation through an executive agreement under Executive Order number 459. Under the hierarchy of Philippine legal rules, AFAS is on PH Tier 3 and is not in conflict, but rather complements and fills the gaps in the Constitution, the PRC law, the Building Code, and the Civil Engineering law. In sum, the IRR of the National Building Code is not explicit in reserving the professional signing authority among Filipino civil engineers. The ASEAN Framework Agreement on Services, which has the same level as the IRR of the Building Code, being an executive regulation, recognizes the license and authority of non-Filipino ASEAN professionals to practice in the Philippines. Again, have a great day and thank you very much. It is now my pleasure to introduce the next speaker, Attorney Fatima Marie Medina.
A pleasant afternoon to everyone joining us live here at UPBGC and online through the Facebook live stream. Now, as some of us may know, There is the National Lottery operated by the Philippine Charity Sweepstakes Office, or PCSO. But there is also the grassroots local lottery called the Small Town Lottery, or STL, which is operated by PCSO through its agents, also known as authorized agent corporations. For this presentation, the question is who exactly may be authorized to operate as an agent corporation for STL in the Philippines. MB Philippines is a domestic corporation wholly owned by non-Filipino investors from within the ASEAN region. MB Philippines Incorporated submitted an application to PCSO for authority to operate as an STL agent. PCSO, however, denied the application outright on the ground of Article 3, Section 9C of the 2020 Small Town Lottery Implementing Rules and Regulations, which provides that STL applicants shall be, among others, 100% wholly owned by Filipino individuals. After exhausting all administrative remedies under the STL IRR, MB Philippines filed a special civil action assailing the validity of Section 9C, Article 3 of the IRR, and seeking to compel PCSO to proceed with the evaluation of its application as an STL agent. Otherwise stated, the issue here is whether or not, as invoked by MB Philippines in this case, whether or not the ASEAN Comprehensive Investment Agreement, specifically Section 5.1 thereof, may be basis to authorize PCSO to engage a domestic corporation owned by non-Filipino ASEAN investors as an STL agent. Speaking of the ASEAN Comprehensive Investment Agreement, or ASEA, this agreement was signed by the Philippine representative on February 27, 2009. It was ratified on August 6, 2009, and the instrument of ratification was deposited on October 26, 2009. Thereafter, the ASEA entered into force on February 24, 2012. Based on these facts, the ASEA can be said to be domesticated by transformation as an executive agreement, and in the hierarchy of Philippine rules, is in the tier of an executive regulation. On the other hand, the 2020 STL IRR was promulgated by the PCSO Board of Directors in Board Resolution Number 18, Series 2020, and approved by the Office of the President pursuant to the PCSO Charter. In this regard, it would appear that the ASEA and the STL IRR are in the same tier of Philippine rules insofar as they are both executive regulations. Nonetheless, applying the rule of lex specialis, it would seem that the STL IRR has more specificity compared to the ASEA with respect to which investors may invest in the state lottery in the Philippines. The STL IRR provides for specific regulations on who may operate as an STL agent in the Philippines with the particular focus on the state lottery. Meanwhile, the ASEA is more general, insofar as it provides for the national treatment, among others, for investors from ASEAN member states within the Philippines. Therefore, with this analysis, it would appear that even though the ASEA is in the nature of an executive agreement in the sphere of Philippine rules, the Philippine rule, the domestic Philippine rule under the IRR would prevail in this case. Therefore, MB Philippines may not be allowed to proceed further in its application to be an STL agent in the Philippines. If there are no further questions, I cede the podium for the next speakers, my esteemed colleagues. Thank you very much.
Great. Thank you very much, Fam. So thanks to our first 5 presenters. And now we'll ask them a few questions, right? Very easy questions. So first, to our class Bido, right? Okay, so please, the microphone is there. And I think the other camera is over there, no? Okay, so for Chris, so you're, can we go back to the slide? Yes, okay, thank you. So as you say, there's a problem because the revised corporation code prohibits a foreign corporation that is not licensed to do business in the Philippines from suing in a Philippine court. And so you pointed to the revised corporation code, which is a statute. So it's a statutory prohibition. Okay? And then you pointed to our ASEAN rule, the ASEAN Comprehensive Investment Agreement, or AKIA, which, as you say, is an executive agreement only, right? No Senate concurrence. Okay? So it's on the same level as an executive regulation only. And you say that AKIA can be interpreted to allow an ASEAN corporation to sue in a Philippine court, even though it has no license to do business here. Okay, so my question would be, isn't there a conflict between the revised corporation code and your interpretation of AKIA? And second, if there is such a conflict, wouldn't the statute prevail over the conflicting executive agreement rule?
Yes, thank you, sir, for the question. So for the first question, sir, I think it could be argued that it would be a conflict, but what I was going for was that it would result in a reinterpretation of the rule such that it would include another exception to the general rule, which is that a foreign corporation cannot file an action in the Philippines unless it is registered and issued a license under the revised corporation code. However, I can also see why it was a conflict. Why it can result in a conflict, since the prohibition is explicit in that it is clear that there's no leeway for a foreign corporation unless it is registered. So I agree, sir, on both. But however, I can also argue that it may be reinterpreted in a way to include the exception. And if there is a conflict, sir, then I would also agree that the revised corporation code would govern, since under the hierarchy of Philippine legal rules, then a statute would prevail over an executive agreement. And in cases of conflict, then it would, then since it is in a higher tier, then it would prevail over an executive agreement. Sir.
Okay, thank you, Chris. Okay. So as we said, we're trying to find case studies where we want the rule of international law, or in this case, the ASEAN rule, to prevail, right? So that we can show that we can actually obtain a type of relief that's not available under Philippine law. Okay, so I'll move to the next presenter. So City, right? So City, I think you were referring to the Consumer Protection Act, right? Yeah, Consumer Act of the Philippines. Okay, so RA 7394. So if we look at the provision that you quoted, it seems to be silent on whether an e-commerce platform like Meta Platforms Corporation, which is the corporation which operates Facebook Marketplace, right? Now, this provision that you quoted seems to be silent on whether e-commerce platforms have the duty to know their client, right? Their online sellers. So it's silent, right? So as you said, there seems to be a gap in Philippine law. Now, when we look at the provision of the ASEAN Agreement on Electronic Commerce that you quoted, Article 7.3, Paragraph A, it says, member states recognize the importance of adopting consumer protection measures. It seems to be silent also on whether an ASEAN state like the Philippines, which is a party to this agreement, has the duty to require e-commerce platforms like Meta Platform Corporation to do KYC. So the agreement is also silent. So there. Do you agree?
Yeah, I agree, sir. But there are several measures in order for to adopt transparent, effective consumer protection. I see KYC as one of these transparent and effective consumer protection because it can build confidence because the customers will be able to validate, identify, and know that really the online seller right there and then could provide for what they have ordered online. So there are several measures. I limit my study to the KYC measure. And the other measure could be subject to other exploration by other case studies as well.
Okay, thank you. So it just says member states know that it's important to have these consumer protection measures, right? And you're taking that as to mean that there's a duty on the part of corporations to adopt these KYC procedures. Okay, thank you. So next would be Dale, right? Sorry, Crystal. Crystal muna. So for Crystal,
Yes, sir.
what's the slide of Crystal? Can we show the slide? Okay. So for Crystal, you were pointing to a provision of the Fisheries Code, right? And you said
That's
the
Prof.
Fisheries Code prohibits a non-Filipino from registering a commercial fishing vessel, right? And so they're prohibited, but then you pointed to AKIA and you said this provision, Article 5, can be interpreted to mean that they're authorized. Foreigners are authorized to register their foreign commercial vessel, right? But then you also said that there is a conflict. There's a conflict between the Fisheries Code and AKIA. So AKIA is a mere executive agreement, whereas the statute is on a higher level. Won't the statute prevail in case of a conflict?
No, I have a different answer, Prof. In my in analyzing the conflict between the Philippine rule and the international rule, sir, the executive agreement, which is in this case is the AKIA, is in the tier 2 of the Philippine of the international legal rule. So it's in the same level as the statute, and so as such, I use the sequential analysis and the statutory construction lex derogat priori. That the later law will repeal the earlier law. In this case, the Philippine rule was that the one to be applied is the AKIA, considering that it will modify the Philippine existing rule, Prof.
Okay. So AKIA is an executive agreement. So under international law, any kind of international agreement, whether it be executive agreement or treaty, would be on the second tier. Because in international law, we don't distinguish as to the kind of the international agreement. It's just, we just see it as an international agreement, that's all. We make a distinction, however, when they are domesticated and they become Philippine legal rules. So executive agreements would be on the third tier only when they are domesticated. Okay, thank you. For Dale. Okay, so for Dale, can we move the slide to Dale's slide, please? So Dale, you pointed to the provision of the PRC Modernization Act, which is a statute, and Article 7J, as you said, requires a foreign professional to come from a country where the foreign license requirements are substantially the same as those of the Philippines. And then you said, how can a Singaporean engineer, right, sign and seal a building plan? And you said it seems to be allowed under the ASEAN Framework Agreement on Services, which is an executive agreement, as you pointed out. And I think what you mean to say is that even if the Singapore licensing requirements are not substantially similar or the same as those of the Philippines, that Singaporean engineer would still be authorized, right, by virtue of AFAS. Okay, and you said this is because there's a gap in Philippine law. Instead of a gap, don't you think that there is a conflict because the Modernization Act, the statute, requires that the licensing requirements of the foreign state be substantially the same? And if you agree that there's a conflict, won't the statute prevail in case of this conflict? Yes.
Thank you, Prof, for that question. I submit that it is more of a gap rather than a conflict because by virtue of AFAS, the Philippine government agrees that these services, professional services, are actually, the requirements thereof are similar within ASEAN region. Hence, if an ASEAN non-Filipino professional seeks to practice in the Philippines, the professional license that he's holding is actually a PRC license by virtue of the AFAS. Hence, it is submitted that there is no conflict, but rather AFAS provides for a specific remedy in case of ASEAN non-Filipino professionals, including engineers, would want to practice here in the Philippines. Thank you, Prof.
Thank you. Thank you very much. So for FAM, yes.
Good afternoon, sir.
Great. So for FAM, your case study shows that, where is it? The IRR, which is on the same level as the AKIA executive agreement, will prevail because of the principle of lex specialis, right? That's what you said. The STL IRR is more specific, so therefore it will prevail because there's a conflict. So my question is, what if you were to argue on the other side? What if you were to argue in favor of the ASEAN investor and you want to be appointed as an STL agent by PCSO? What argument can you use to show that the ASEAN, the foreigner, the ASEAN investor is actually authorized to be an STL agent, whether you can invoke AKIA, and in this case you can say that AKIA will prevail, or some other argument?
Thank you very much for the question. On the side of the MB Philippines in the test case, one argument would be reference to the obligation of the Philippines of Pacta Sunt Servanda under the Vienna Convention on the Law of Treaties. Article 27 of this treaty provides that a state party may not invoke its internal law as justification to perform a treaty obligation. So in the case of the Philippines, MB Philippines may argue that since the Philippines is a state party to the VCLT, it cannot invoke the STL IRR as a basis for it not to give the same treatment to MB Philippines, the treatment that it gives to Philippine investors in STL.
Okay, thank you. Thank you very much, Fam.
Thank you.
So we'll now go to our presenters 6 to 10, right? May I invite our next presenter, Attorney Greg Nunag Jr.
Good afternoon, everyone. In my case study, I will talk about the ASEAN Agreement on Customs, or AAC. I wish to invoke it as basis to compel the Bureau of Customs, or BOC, to accept the recordal in the BOC registry of foreign trademarks that have been registered in ASEAN states, even if they do not have Philippine registration in the Intellectual Property Office of the Philippines, or IPO, under the IP Code. The Philippine law problem that I seek to solve is this. BOC refuses to record ASEAN foreign registered trademarks. The ASEAN law solution that I propose is that the AAC has been domesticated as an international rule and is binding to the Philippines with the force of a Tier 3 law. Further, the AAC contains a provision mandating the customs authorities of the ASEAN states to provide mutual assistance to each other in the suppression of intellectual property rights violation. Let us consider this hypothetical case. SGT Corporation, a Singapore company, is the manufacturer of a growing product line of high-end solid-state drives for industrial applications. The brand is starting to gain traction in the ASEAN market for its reliability, ruggedness, versatility, and cost efficiency. SGT Corporation carries the mark SGT, for which the company obtained a trademark registration in the IPO of Singapore for goods in International Class 9 covering computer storage media. Recently, SGT Corporation received a tip that several shipments of fake SGT drives are en route to the Philippines. SGT immediately lodges a customs recordation in the BOC to block the said shipments. However, the BOC refused the recordation because the SGT mark is not Philippine registered, neither is it internationally well known. Aggrieved, SGT elevates the BOC's decision to the Secretary of Finance in order to compel the recordation. Philippine rule. The provision of Philippine law under scrutiny is CAO 9-2008, which is Customs Administrative Order creating the BOC's Permanent IPR Division. Its Section 2, letter C states, the BOC shall maintain an IPR registry upon the submission of certified true copies of a certificate of registration issued by the Intellectual Property Office, or certified true copies of a decision or resolution of a court or other competent authority declaring or recognizing the claim to the IPR. Further, its letter B states that the following are prohibited. Those which shall copy or simulate any mark or trade name registered with the IPO in accordance with the IP Code, or those which shall copy or simulate any well-known mark as determined by competent authority. From this, it is clear that CAO 9-2008 only accepts Philippine registered trademarks for customs recordation. The only exceptions are internationally well-known marks declared as such by competent authorities, meaning those which are declared in proper proceedings as world famous and are afforded a higher protection in international conventions such as the TRIPS Agreement. The importance of customs recordation is that it constitutes as a continuing complaint against the entry of fake goods. Border enforcement prevents counterfeit goods from contaminating the market and saves the legitimate brand owners from the trouble and expense of inland enforcement through the filing of damage suits and criminal actions. Having stated our problem, let us first surmount the question of the domestication of the proposed international rule, the AAC, before we proceed to apply the international law solution, domestication. The AAC was signed in Cambodia on March 30, 2012 by the country representatives of all ASEAN states. Finance Secretary Purisima signed for the Philippines. The AAC went into force on November 7, 2014 upon the ratification by Malaysia, the 10th state to ratify it. On January 6, 2014, President Benigno Aquino III ratified the AAC through Executive Secretary Ochoa. Thereafter, the instrument of ratification was deposited to and received by the ASEAN Secretariat. The AAC did not have Senate concurrent, but that fact notwithstanding, the AAC was domesticated in the Philippine legal system as an executive agreement through the method of transformation when the Philippine President ratified the AAC. It is settled in our jurisprudence that executive agreements are valid upon the ratification by the President even without the Senate's concurrence. Although in the legal hierarchy, the AAC only enjoys Tier 3 standing or the equivalent of an executive regulation. Having surmounted the question of domestication, let us proceed to tackle the solution, international rule. Article 43 of the AAC fills the gap in Section 2, letters B and C of CAO 9-2008, which provides for a comprehensive administrative and operational framework for customs recordation. CAO 9-2008 does not cover ASEAN foreign registered trademarks. On the other hand, in the international sphere, Article 43 of the AAC directs the customs authorities of the ASEAN member states to help each other in the suppression of IPR infringement. It states, custom authorities of ASEAN member states shall endeavor to provide mutual administrative assistance to each other for the prevention, investigation, and repression of IPR infringements. It must be stressed that customs recordation is inevitable in any reciprocal border enforcement between states for the suppression of IPR violations. The presence of the word endeavor in Article 43 does not diminish the clause. On the contrary, it intensifies the response that is expected of the ASEAN states. Endeavor in its ordinary meaning is to try hard to do or to achieve something. Therefore, the phrase shall endeavor to provide presents a stronger command. Article 31 of the Vienna Convention on the Law of Treaties commands that a treaty shall be interpreted in accordance with the ordinary meaning to be given to the terms of the treaty. To summarize, the BOC refuses to record the ASEAN foreign registered trademarks, but Article 43 of the AAC, a domesticated international rule, compels the BOC to accept them and to enforce protective border control. Thank you. Our next speaker is Attorney Vertiliano Relevo.
Thank you, Attorney Greg Nunag. Good afternoon, everyone. The legal problem in my case study is a non-Philippine ASEAN insurance company not licensed to do business cannot file a civil case. And the relief sought is to authorize a non-Philippine ASEAN insurance company not licensed to do business to file a civil case. This involves a non-Philippine ASEAN investor which engages in a business in the Philippines. Such an investor then insures the investment against expropriation with a non-Philippine ASEAN insurance company. Now the Philippine government expropriates an asset of the business. As a result, the insurance company covers the loss from the expropriation. The question now is, can the non-Philippine ASEAN insurance company file a case for the computation of just compensation? The relevant Philippine rule is the revised Corporation Code, Section 150, which does not permit a foreign corporation not licensed to do business in the Philippines to maintain or intervene in any proceedings. On the other hand, the relevant ASEAN rule is the ASEAN Comprehensive Investment Agreement, Article 15, which stipulates that if an insurer has covered the losses suffered by an investor in a host state, then the host state will recognize the subrogated right of the insurer to bring the investor's claim. Now, the ACIA was only ratified by the President in 2009 and not concurred by the Senate. This means that in the hierarchy of Philippine rules, it has the status of an executive regulation. My position is that its status as an executive regulation is sufficient to fill a gap in the law. This is because the Department of Trade and Industry, an executive department, has provided exceptions to the phrase doing business in its implementing rules of Republic Act 7042 or the Foreign Investment Act. And an analysis of these exceptions shows that they are activities that are not directly connected with the main business of creating or earning profits in the Philippines. Also, the purpose of the law in requiring a license is to ensure that both the state and the locals would have a valid means of obtaining jurisdiction over the persons. This is not the case with a sub-rogae foreign insurance corporation because they themselves submit jurisdiction over their person to sue in the Philippines. So the conclusion is that AKIA Article 15, with a status as an executive regulation, provides a new exception to the phrase doing business. In other words, while the filing of a case as a consequence of subrogation is incidental to the insurance business, it is not directly connected with the main business of soliciting insurance. Thank you. I now introduce you to the next speaker, Attorney James Yolon.
Good afternoon. Today, I will present my case study entitled ASEAN Agreement on Electronic Commerce as a Basis to Compel Online Sellers Using Facebook Marketplace to Register with the Department of Trade and Industry. The current problem I want to address with my case study is the proliferation of scamming among online sellers on Facebook Marketplace. Last year, Facebook Marketplace passed 1 billion global users. And based on the data provided by Facebook Meta, the Philippines was among the top users of Facebook worldwide as of July 2020. We ranked 6th with around 76 million users, behind countries such as United States and India, which topped the list with more than 100 million users. One recent survey revealed that 1 in 6 or 17% respondents had been defrauded on the site. But of course, much of the commerce on this classified ad section of Facebook is legitimate. But like any other online marketplace, it also attracts plenty of scammers. And because people view sellers' profiles, they feel more assured of safety and security on the site. Unfortunately, this is often a false sense of security. The Department of Trade and Industry is a primary implementing agency of the Consumers Act of the Philippines and the ASEAN Agreement on Electronic Commerce in the country. Aside from that, DTI is mandated to provide coherent, consistent, and transparent trade and industrial policy recommendations supporting the National Economic Development Agenda. Through DTI registration, online sellers will be regulated and monitored by the agency and can be held liable for whatever violation they will commit against their consumers. In analyzing the feasibility of this case study, I will be applying the 7 steps analysis in presenting my arguments. First, Article 5, Paragraph 1 of the ASEAN Agreement on Electronic Commerce provides that in the development and promotion of e-commerce, the role of each member state shall be geared towards providing an enabling legal and regulatory environment, a conducive and competitive business environment, and protecting the public interest. Thus, as a signatory of this international agreement, the Philippines must adopt a policy or increase the implementation of existing laws. Second, ASEAN Agreement on Electronic Commerce is considered an international agreement subject to treaty rules. Third, ASEAN Agreement on Electronic Commerce is binding in the Philippines as it was signed on November 12, 2018 and was ratified on January 22, 2019. Fourth, the Consumers Act of the Philippines, enacted in 1992, protects consumers from various harms and risks from daily purchases and consumptions. However, this law does not have any provision that expressly protects the consumers in an online platform such as Facebook Marketplace, which becomes the breeding grounds of bogus online sellers. Fifth, it has a similar status of an executive regulation in the Philippine hierarchy of legal rules. Sixth, It fills the gap in the Philippine rules since it would empower the execution of the Philippine Consumers Act, which lacks protections for consumers who use online platforms in their purchases. And finally, while the Consumers Act of the Philippines provides for general protection of our consumers, it is essential to recognize that it has a gap that needs to be filled to materialize its mandates. Hence, we can invoke ASEAN Agreement on Electronic Commerce as a basis to compel online sellers using Facebook Marketplace to register with DTI. Thank you and good afternoon. And may I now have the honor to present our next presenter, Attorney King Anthony Perez, via Zoom.
Thank you, James. In the Philippine jurisdiction, proceeds of a crime shall be forfeited in favor of the government. Concerning this forfeiture rule, the question on what should be done to proceeds that are found to be commingled with the legitimate sources of property of an offender found guilty of the crime of human trafficking arises. In a U.S. Department of State report, there are 1,297 prosecutions that have remained ongoing in the Philippines. When alleged traffickers are found guilty later on, how should the court squarely address the issue of commingled proceeds with the legitimate sources of property of the offender? These are some of the questions my case study attempts to seek answers based on the existing domestic and ASEAN legal instruments. In sum, it must be legal and valid to authorize the confiscation of trafficking proceeds up to the assessed value of intermingled proceeds with those acquired from legitimate sources. As to the domestic law, the Anti-Trafficking in Persons Act of 2003, despite being amended twice in 2012 and 2022, has retained its original provision on confiscation of proceeds and properties. Under the said provision, when proceeds, properties, and instruments of the offense, which may have been concealed, removed, converted, or transferred to prevent the same from being found, or to avoid forfeiture or confiscation rather, the offender shall be ordered to pay the amount equal to the value of the proceeds. As observed, the provision fails to address a specific situation when the proceeds or properties of the offender have been intermingled with property acquired from his or her legitimate sources, as the said provision are couched on more general terms. On the other hand, the ASEAN Convention Against Trafficking in Persons, especially women and children, authorizes confiscation even when it is intermingled with proceeds or properties from legitimate sources up to the assessed value of intermingled proceeds. Not only that it contemplates a unique situation of commingling such proceeds, it also spells out a specific valuation for confiscation, which is the assessed value of the joint proceeds of both illegal and legitimate sources of property of the offender. The ASEAN Convention Against Anti-Trafficking in Persons is a binding legal instrument because it is an international agreement in the form of an executive agreement signed on November 21, 2015 by then President Benigno S. Aquino III and subsequently ratified on February 6, 2017. The same agreement has been domesticated under the Philippine legal system. Being an executive agreement, the ASEAN Convention Against Anti-Trafficking in Persons needs no Senate concurrence to be domesticated under the Philippine legal system. While I acknowledge that the Philippines Anti-Trafficking in Persons Act of 2003 sits in a higher position than the ASEAN Convention Against Anti-Trafficking in Persons, in the hierarchy of laws in the Philippine legal system, there shall be no legal controversy over the matter, as it appears that the ASEAN Convention Against Anti-Trafficking in Persons merely fills in the gaps in Anti-Trafficking in Persons Act of 2003 in the Philippines. Nothing in the domestic law expressly provides to prohibit addressing the problem pointed out by my study. Hence, a sequential analysis used in the cases of conflict of laws is of no moment in this study. Now, may I introduce to you Judge Earl Warren Castillo for his case study presentation.
Good afternoon, Professor Raj. Good afternoon, classmates. This afternoon, I shall endeavor to show that the ASEAN Convention Against Trafficking in Persons, or the ACTIP for short, may serve as basis to authorize the garnishment in a civil case of the foreign currency deposits of a fugitive from justice. The hypothetical factual backdrop of my case study involves the following. Namor, an Indonesian, is charged with violation of the expanded Anti-Trafficking in Persons Act of 2022, or RA 9208 as amended by RA 11862. He is arrested but subsequently escapes. One of his victims, Feliz, a Filipina, discovers Namor's locally held US dollar deposits with United Bank, which is based in the Philippines. She thus refers her predicament to her counsel for the filing of an action for civil damages against such deposits. Her counsel, however, declines to take on her case on the ground that under existing Philippine laws, even including the expanded Anti-Trafficking in Persons Act, foreign currency deposits remain exempt from garnishment. The problem that this case study thus seeks to tackle is that the US dollar deposits of a fugitive from justice cannot be garnished. Accordingly, the relief sought in this case is to authorize the garnishment in a civil case of US dollar bank deposits of a non-Filipino ASEAN citizen who is a fugitive from justice. The applicable provision of law in this case is Section 9D of the expanded Anti-Trafficking in Persons Act. It will be noted that while the provision provides for an exception to the rule of secrecy of bank deposits, it accords or extends the right or authority to inquire into bank deposits only to law enforcement agencies. It is therefore silent as to whether a complainant or a victim of trafficking himself or herself may inquire into or seek a disclosure of the foreign currency deposits of an offender. The applicable international rule in this case, as stated, is the ACTIP, particularly Article 17, Paragraph 6, which is reflected in my slide, and Article 14, Paragraph 13 also, which is not reflected for lack of space, but I shall read the same. Article 17, Paragraph 6 states that for the purposes of this article and Article 21 of the Convention, each party shall empower its courts or other competent authorities to order that bank, financial, or commercial records be made available or seized. Each party shall not decline to act under the provisions of this paragraph on the ground of bank secrecy. Article 14, Paragraph 13, meanwhile, of the same convention, states that each party shall ensure that its domestic legal system contains measures that offer victims of trafficking in persons the possibility of obtaining compensation for damage suffered. It will thus be noted that the first provision imposes a duty upon a state party, such as the Philippines, to authorize its courts to make financial records available, and it also imposes a negative duty upon a state party of not invoking bank secrecy. The second provision, meanwhile, imposes similarly a duty on a state party to afford or give the victim of trafficking the opportunity to obtain compensation for damage suffered. Both provisions notably seek to promote the protection of victims of trafficking. Applying the seven-step analysis, I respectfully submit that the said provisions or the ACTIP itself is a binding rule of international law on the Philippines, considering that it was signed on November 21, 2015. It was ratified by the President on January 24, 2017. The instrument of ratification was deposited on February 6, 2017, and it entered into force on March 8, 2017. Considering that the instrument or the convention bears no Senate concurrence, it partakes the nature of a Tier 3 rule under the Philippine legal system, or the equivalent of an executive regulation. I respectfully submit that considering that Article 17, Paragraph 6, and Article 14, Paragraph 13 of the Convention do not appear to directly conflict with Section 9D of the Expanded Anti-Trafficking in Persons Act. The said provisions of the Convention provide and the said provisions of the Convention fill in a gap in the domestic rule, and that gap is the silence of the provision as to the right or authority of a victim of trafficking to seek the disclosure and eventual garnishment of foreign currency deposits of an offender. With that, I end my presentation, and I have the honor of introducing our next presenter. I'm last pala. All right.
Thank you very much, Judge Warren. So, as we said, we're going to invite the presenters to sit in front so that you can answer the questions. No? So we have Attorney Greg, and then Attorney Yaki, I think, and then, okay, sige. So Attorney Greg first. Okay. Ready? So the microphone is here, huh? So, yeah. And the camera is over there. Okay, so a few questions for Attorney Greg. This is an IP case, no? Yes. IP case, okay. So you focused on the ASEAN Agreement on Customs, which has provisions on protection of intellectual property rights, and you're invoking that provision of the international agreement to enforce the right of a foreign trademark owner, right? Yes. Okay. So you focused on this provision, Article 43, and and you also discussed the term endeavor. I think you saw the issue in the article, in the provision, no? When we say endeavor, I know you had that explanation, but doesn't the term endeavor mean try, just best effort? Meaning the Bureau of Customs really has no duty of customs recordation of the ASEAN trademark? That's the first question.
Yes.
And then the second is, you said that there is a gap, right? So there's a gap between the provisions of this executive regulation and it's being filled by the executive agreement,
Yes,
right? So yes, there may be a gap with that executive regulation, but isn't there also a conflict with the IP code, which is a statute? Because my understanding, I may be wrong, is that the IP code requires the Philippine registration of a trademark before the trademark may be protected under Philippine law, and the exception just being an internationally recognized mark. Yes.
Yes, Pop. Thank you for the questions, Professor Raj. Actually, the observations are correct. I'll go first with the first question on the usage of the word endeavor. Okay. As I have explained in my presentation, endeavor means a higher intensity action, because it means to try hard in order to fulfill the goal. And so it is also arguable that endeavor here presents actually a higher intensity action. And second, and these things will appear in my final paper, I have made survey of certain local legislations that use the word endeavor. And actually endeavor does not necessarily mean a mere suggestive posture. One example that I can cite is the Universal Healthcare Act, endeavor was used several times, and it did not mean only as a suggestive matter. And finally, I've also surveyed the usage in the international uh, legal sphere of the word endeavor. And it's very interesting to note that when you say endeavor, it actually means reasonable endeavor. And reasonable endeavor means you have to exhaust everything that is prudent in order to get to your goal. In fact, there's also a best endeavor. And so all of these things will appear in my final paper. So I will use statutory or treaty interpretation, both in the domestic sphere and the international sphere, Prof. On the second question, yes, it is correct. In fact, it is a primary rule that trademark rights are territorial. But in this particular instance, we are enforcing border control, and therefore this is actually preventing the goods from entering into the market. The IP code, the claim for damages or the criminal prosecution focuses on inland enforcement when the goods are already inland. But this one is actually blocking them from the border, and the right here arises from an ASEAN law which requires a customs cooperation with other ASEAN states. Thank you.
Very good. You seem prepared with your answer. Okay, next we'll invite Attorney Relevo. Relevo. Attorney Relevo. Okay. Where are you broadcasting from, Attorney Yaki?
From Cebu City, Prof. Raj.
Ayo. Okay. So your case study focuses on the revised corporation code, and you pointed to the prohibition in section 150 on a foreign corporation suing in the Philippines if the corporation has no license to do business here. And in your case study presentation, you also talked about the exceptions under the Foreign Investments Act. Aren't the facts of the case study already covered by such exceptions under FIA? Meaning, do we really need to use the ASEAN Comprehensive Investment Agreement to obtain the relief that we seek?
Thank you for the question, Prof. Raj. So we need to invoke the ACIA Article 15 because it is not one of the specific conducts that are exceptions to the phrase doing business. But it can be inferred from the implementing rules of the Foreign Investment Act that, like ACIA Article 15, the exceptions are considered as such because they are not directly connected to the main business of creating or earning profits in the Philippines. In other words, ACIA Article 15, an executive regulation like the Foreign Investment Act, provided for a new exception. Thank you.
Okay, thank you, Attorney Yaki. So next would be, Attorney James. All right, from Bukidnon, right? Wow, Valencia City, Bukidnon, right? Okay, so for Attorney James, so you're focusing on the Consumer Act, right? RA
Yes, Prof.
7394, and you seem to have said that there's a gap, right? There's a gap in the law, and the law does not afford protection for online purchases. It doesn't protect consumers who are engaging in online transactions. Okay, so, and then you pointed to this ASEAN Agreement on Economic Commerce. I was looking at Article 5, Paragraph 1, and I was trying to look for, some text which suggests some hard obligation, some duty on the part of the Philippines, or even on the part of online sellers, right, to register with DTI. So before I go there, okay, well, that's the first question. The agreement does not seem to require DTI registration. Okay, it's not very specific. How can we use Article 5.1 to obtain the relief that we want? Right, that's the first question. And then the second one, what we want is the online sellers to register with DTI. And registration with DTI is actually a requirement also for BIR registration, right? So if they are a single proprietorship, they'd have to register with DTI. If they're a partnership or a corporation, with SEC. Can't we use existing Philippine legal rules to indirectly obtain the relief that we want? So what we want is we want them to register with DTI. But if we enforce Philippine rules on tax requiring them to register, they'd still need to register with DTI. So can't we use existing Philippine legal rules to obtain the relief that we want?
Thank you, Prof. I'll answer the first question pertaining to um, the question pertains to the interpretation of the ASEAN Agreement on Electronic Commerce, Article 5, Paragraph 1. It's very clear here that there is an obligation in a member state that it has to gear towards providing legal and regulatory environment. Under Article 6, Paragraph 2, Prof, of RA 7394, it provides there that if there are certain gaps that the law does not provide herein, then the DTI or the Department of Trade and Industry shall have the obligation to fulfill it. So since in relation also to your second question, the DTI has the mandate under our executive branch to regulate the trade and industry, while the taxation also has a different legal effect on our sellers or business enterprises. But in a simple registration or simple protocols on registering a business, the DTI registrations precedes with BIR registration. So here, since the law provides that DTI has a direct mandate, so we could also interpret it in a verbal legis that DTI should be the agency in the Philippines required by the ASEAN rule to fulfill and guarantee the protection of our Consumer Act of the Philippines, or RA 7394, to guarantee the welfare of our consumers, Prof. Thank you.
Okay, thank you. Thank you very much. Okay, so I now invite Attorney King,
Good
Attorney
afternoon,
Perez,
Prof.
also from Cebu, also in Cebu now?
Yeah, same with Mr. Relevo.
Okay. So King's case study focuses on proceeds of crime, right? And you pointed to RA 9208, and you said that there's a gap. Tama ba? There's a gap?
Yes.
Yes, there's a gap because the law does not authorize confiscation when illegal proceeds are commingled. Okay, so that's with regard to the anti-trafficking. So my first question is, if we read the provisions of Section 14, and it says when the proceeds have been concealed, so doesn't that cover commingling? You know, in an effort to conceal, we commingle. So doesn't the statute already authorize confiscation even when it's commingled by the phrase concealed? And then second, I was thinking, isn't there a so yeah, anyway, that's the question. Yes.
Okay. Thank you for pointing it out, Prof. So, to answer the question, as discussed earlier, I actually pointed out to that provision in the domestic law, stating that it actually pointed out that for those proceeds that may be concealed, the offender may be ordered to pay the amount equal to the value of the proceeds that may be found later on during the trial of the case. However, I highlighted and emphasized that the said provision are couched on more general terms compared to what we have in the ASEAN Convention Against Trafficking in Persons, especially women and children, which particularly addresses the situation when the intermingled proceeds or properties from legitimate sources of the offender will be confiscated up to the assessed value of the intermingled proceeds. I carry the opinion that it fills in a gap in the domestic law because one of the indicators of a good law, I think, is the predictability, meaning that we could address a specific situation with a particular remedy or solution. And I believe that the ASEAN agreement provides the remedy for this situation, unlike in the current domestic law, which could be subjected to many interpretations. And I would like to delve more into that into my case study.
Center, I'm going to invite si Judge, no? Judge Castillo. We have a few questions for Judge Castillo. You pointed to RA 9208, and it has provisions regarding, what is this? 9205, inquiry or examination of deposits, right? But there seems to be no provision regarding garnishment, right? The statute does not, the Philippine rule does not authorize garnishment. So you said that there's a gap. So if there's a, okay, so there may be a gap with this statute, right? But I'm also referring to a law that you also mentioned, the bank secrecy law. Now, with regard to that law, that seems to be very clear that foreign currency deposits are not subject to inquiry or even garnishment. So isn't there a conflict between that Philippine statute and this executive agreement which we're invoking as basis for our claim? And second, so we know that this is an executive agreement, right? So there may be a conflict. Now, even assuming that this ASEAN agreement is a treaty, okay, it's not, it's an executive agreement, but assuming it's a treaty on the same level as statute, won't the bank secrecy statute still prevail because of the principle of lex specialis? So those two questions, Judge.
Assuming it's a treaty, sir, won't bank secrecy?
Yes, so the first one, isn't there a conflict with bank secrecy law? And second, assuming that it's a treaty, won't the statute still prevail because of lex specialis?
Yeah, thank you for the questions, Professor. With respect to the first question, as to whether there is a conflict between RA 9208 as amended and the ASEAN Convention, it would seem to appear that way, considering that RA 9208 is a statute, while the convention is a mere executive regulation. I submit, sir, that there is in fact no conflict because our Section 9D of RA 9208 actually cites or creates another exception to the rule on secrecy, and the ASEAN Convention supplements or fills in this gap by reaffirming the obligation of state parties to ensure disclosure of the subject deposits. While garnishment is not expressly mentioned, I submit that the garnishment would necessarily follow where the subject deposits are allowed to be disclosed. With respect to the second question, sir, assuming that the convention is a treaty, will the law on bank secrecy prevail, considering that they are on this at par with each other as law? I submit that the ASEAN Convention should prevail, assuming it is a treaty, on the ground that the Philippines as a state party should not back down on its obligations under the rule of Pacta Sunt Servanda.
Okay, thank you very much,
Thank you, sir.
Judge Earl. I'm now going to invite our next 5 presenters, and we'll begin with Attorney Iris Pozon.
Hello, good afternoon, everyone. Actually, the problem I'm presenting sounds very simple. that there is an absence of a single official criminal database in the Philippines. Imagine the situation. John Doe, a non-Filipino ASEAN national, was killed by still unidentified riding in tandem individuals in one of the inner streets of Tondo, Manila. Now his family, which happens to be based abroad, hopes to secure further information on his killing in order to eventually retain the services of a private counsel to prosecute his case here in the Philippines. Unfortunately, there is no ready mechanism to secure those information, and the data and documents needed has to be facilitated or coursed through various Philippine government agencies. Likewise, some of those agencies unfortunately invoke the Executive Order Number 2, which essentially operationalizes the executive branch relative to the public information in such to decline access to information. Under EO Number 2, which was signed in 2016, access to information, every Filipino shall have access to information, official records, public records, and to documents and papers pertaining to official acts, transactions or decisions, as well as to government research data used as basis for policy development. However, there is no provision under this text which grants the access to information to non-Filipino ASEAN nationals. Likewise, under the international rules, this representation submits that under the ASEAN MLAT, or the Treaty on Mutual Legal Assistance in Criminal Matters, will somehow resolve the situation in compelling the Department of Justice to create a national database of EJK cases to facilitate a more expeditious investigation, prosecution, and trial of criminal matters involving EJK. Under the ASEAN MLAT, the parties shall, in accordance with the treaty and subject to their respective domestic laws, render to one another, and I put emphasis on this, the widest possible measure of mutual legal assistance in criminal matters, namely investigation, prosecutions, and resulting proceedings. Now, read with Article 4 of the ASEAN MLAT, the ASEAN MLAT under Article 4 designates a central authority, in this case the Department of Justice of the Philippines, specifically the Office of the Chief State Counsel, to provide this data. However, again, there is no ready mechanism or database for the provision of those information. Now, I submit that applying the 7-step process, I believe that the ASEAN MLAT may be readily applied, being first of all a treaty or an international agreement, having been signed by the Philippines on 2004. This was likewise ratified by the President on October 2006, and an instrument of ratification was deposited on December 2008. So the question now is whether or not the ASEAN MLAT has been domesticated. This representation submits that yes, it has been domesticated via transformation, with the Senate concurring on the treaty sometime in 2008 by way of Senate Resolution Number 126. Now, applying the hierarchy, the ASEAN MLAT takes on the position of a Philippine statute falling under Philippine Tier 2, which takes a higher position compared to our Tier 3 executive order. Now, applying the ASEAN MLAT will somehow resolve the situation in that it will fill a gap in the Philippine law, considering the FOI order, or EO number 2, essentially only services the right to access to information of Filipino citizens. And that actually ends my presentation, bro. May I now introduce Attorney Charlene U. De Leon.
Good afternoon, everyone. My name is Charlene Ann U. De Leon. In my presentation, I seek to address the predicament of drug importers and foreign drug manufacturers which arose from the suspension of the conduct of foreign inspection by the Food and Drug Administration due to the COVID-19 pandemic. To give a brief background of the problem, drug importers and foreign drug manufacturers are required to apply for a good manufacturing practice or GMP clearance from the FDA. They are required to present satisfactory evidence to prove that it is compliant with current good manufacturing practices. Otherwise, it will be required to pay for and be subjected to foreign manufacturing site inspection by the FDA Drug GMP Inspectorate Task Force as a condition precedent for the issuance of the FDA clearance for importation of medicinal products. Due to the COVID-19 pandemic, however, the conduct of foreign inspection is temporarily suspended until further notice. Thus, FDA Circular Number 2020-20 states that applications which are not satisfactory shall not be issued a permit to register and shall be subject for inspection upon resumption of foreign GMP inspection. Hence, drug importers and foreign drug manufacturers that are required by the FDA to undergo foreign GMP inspection have no other recourse but to wait for the resumption thereof by the DFA task force. In lieu of waiting for the resumption of foreign GMP inspection, it is proposed that a special civil action be filed to compel the FDA to make a request to the National Drug Regulatory Authority of the relevant ASEAN member state to assess and certify that a foreign manufacturer is compliant with GMP pursuant to Article 8 of the ASEAN Sectoral Mutual Recognition Arrangement for Good Manufacturing Practice Inspection of Manufacturers of Medicinal Products. The subject ASEAN agreement was entered into by ASEAN member states primarily for the purpose of facilitating the movement of medicinal products within the ASEAN. It entered into force on April 10, 2009, upon signature of the authorized representatives of the ASEAN member states without the need for an instrument of ratification. In this case, the subject agreement was signed by then Secretary of Trade and Industry, Peter B. Favela. Under Article 8 of the said ASEAN agreement, it states that a national drug regulatory authority may request another NDRA to assess and certify that the manufacturer of a medicinal product is licensed or authorized to manufacture that medicinal product or has been regularly inspected for compliance with GMP standards. Since the ASEAN agreement is conventional international law, it needs to undergo the process of domestication under the Philippine national legal system. In this case, the subject ASEAN agreement was entered into without the need of Senate concurrence and is considered an executive agreement. In the hierarchy of rules under the Philippine national legal system, an executive agreement is considered part of the third tier or equivalent to rules created by the executive department. In other words, it has the same status as implementing rules and regulations or administrative orders in the Philippines. Since the ASEAN agreement and the FDA circular belong to the same tier, there is no conflict between the two. In fact, the domestication of this ASEAN agreement fills a gap in the Philippine legal rules as it provides drug importers and foreign drug manufacturers an alternative to merely waiting for the resumption of FDA GMP inspections. With the application thereof, they now have a course of action under the ASEAN agreement to compel the FDA to make a request to the National Drug Regulatory Authority of the relevant ASEAN member state to assess and certify that the foreign manufacturer is compliant with good manufacturing practices. This concludes my presentation. Thank you. And I would now like to introduce the next speaker, Attorney Dwight Anthony Yu, who will be presenting via Zoom.
Good afternoon, everyone. My topic is the agreement on the ASEAN Food Security Reserve as a basis to authorize the National Food Authority to create a national food reserve for basic food stocks. The Philippine problem is the rising prices of food and shortage of basic food commodities. In a hypothetical case, Juan, a Filipino minimum wage earner, is having a hard time bringing food to the table for his family of six due to the increase in food prices and short supply of lowland vegetables, pork, and fish. The National Food Authority seeks to create a national food reserve for basic foodstuffs on the basis of the aforementioned agreement. Applying the seven-step process, first, the agreement on the ASEAN Food Security Reserve, Article 2 provides that the governments of the ASEAN member countries hereby agree to establish the ASEAN Food Security Reserve. It means the sum total of food stocks maintained by each ASEAN member country. Second, it is considered as an international agreement and is governed by treaty rules. Third, it is binding on the Philippines as it was signed at New York on October 4, 1979 and ratified on November 23, 1979. Fourth, it was partially domesticated by RA 11203, which mandates the creation of a rice buffer stock. Fifth, it is on the same level as a statute in the hierarchy of the Philippine legal rules as it was ratified pursuant to the Prime Minister's powers under the 1973 Constitution. Sixth, as an effect, it fills a gap in the Philippine legal rules. Seventh, applying it to the Philippine case, RA 11203 mandates the creation of a rice buffer stock, but not for other basic food stocks. The ASEAN Food Security Reserve can be a basis for the NFA to create a national food reserve for all basic food stocks. Other ASEAN nations, which are also signatories to the agreement, such as Indonesia, have laws on food reserves which covers rice, corn, poultry meat, poultry eggs, sugar, cooking oil, and fish. That would be all. Thank you. I would like to introduce the next presenter, Attorney Francis Dignadice.
Thank you, Attorney Yu. Good afternoon, Prof. Good afternoon, classmates. Our current problem is indicated in the PowerPoint slide. Dentist committed malpractice in home state but still working in the Philippines. Before we resolve that problem, here's the factual milieu. There's a licensed dentist in Malaysia, namely Dr. Strange Fate. To likewise practice dentistry in the Philippines, he applied for a license here in the country. The Board of Dentistry of the Professional Regulations Commission, or PRC, granted him a registration certificate by virtue of the ASEAN Mutual Recognition Arrangement, or MRA, on dental practitioners, the ASEAN Framework Agreement on Services, or the AFAS, the PRC Modernization Act, and the Philippine Dental Act. On one occasion, Dr. Fate was grossly negligent and committed malpractice on a patient in Kuala Lumpur, resulting in his instantaneous death. After due proceedings, the Malaysian Dental Council revoked the license of Dr. Fate to practice dentistry. Even though the license of Dr. Fate was already cancelled by the Malaysian Council, he still practices dentistry in the Philippines. A Filipino patient of Dr. Fate, Attorney Braces, got wind of the revocation of the license of Dr. Fate through a lawyer friend based in Kuala Lumpur, who has handled the malpractice suit against the said dentist. Since Attorney Braces is fully aware of the MRA, he filed an administrative case for revocation of Dr. Fate's dental license with the board. The relief sought is to declare as revoked the license of a non-Filipino ASEAN dentist due to malpractice in his home state. The applicable Philippine rule is RA 9484, or the Philippine Dental Act of Article 4, Section 31 states, unless the country of which he is a citizen specifically permits Filipino dentists to practice within its territorial limits on the same basis as the citizens of such foreign state, under reciprocity and under international agreements, no foreigner shall be given a certificate of registration to practice as a dentist and be entitled to any of the privileges under this act. While the applicable international law, as embodied in the ASEAN Economic Agreement, the MRA, Article 3, Section 3.1.5 states, a foreign dental practitioner may apply for registration in the host country to be recognized as qualified to practice dentistry in the host country in accordance with its domestic regulations and subject to the following condition. He has been certified by the Professional Dental Regulatory Authority, or PDRA, of the country of origin of not having violated any professional or ethical standards. in relation to their practice of dentistry in the country of origin, as far as the PDRA is aware. AFAS and MRA were signed by the DTI Secretary on December 15, 1995, and February 26, 2009, respectively. Philippines is bound under international law since AFAS is an executive agreement inasmuch as it was ratified by the President on March 18, 1996. Since MRA is derived from the AFAS, it has a similar force and effect as the AFAS. Thus, the aforementioned agreements may be considered rules of conventional international law. The Philippines consented to be bound by those agreements and complied with the requirements of those agreements with the signature of the DTI Secretary, the country's authorized representative. The country did not make any reservation when it expressed to be bound by those agreements. The foregoing ASEAN legal rules, particularly AFAS, were domesticated into Philippine law since the President has ratified it. It is provided under EO 459 that even without Senate concurrence, an executive agreement is domesticated into the Philippine national legal system through its ratification by the President. Considering that the agreements are executive agreements, they belong to Tier 3 since they have the same status as a rule embodied in an executive regulation. The ASEAN agreements fill the gap in the PRC Modernization Act and the Dental Act since both of these Philippine legal rules do not provide for the legal right, remedy, or relief to cause the revocation of the license of a practitioner of another AMS whose license has already been revoked by his country of origin. Those statutes do not also provide in a specific manner the obligation of the board to revoke the license of such unscrupulous dental practitioner. Whereas the ASEAN agreements provide in a specific manner the rights, relief, and remedy, since the MRA specified the mechanism on how the board can be formally notified of the revocation of the license of a professional by his country of origin. Before the implementation of the MRA, the board was in the dark on the professional status of a practitioner of another AMS, whether or not his license to practice is still existing or has already been revoked. Thus, the domesticated ASEAN agreements can be applied in a Philippine case in order to obtain the desired relief under the Philippine legal system. Thank you. May I now introduce the next presenter, Attorney Martina Datuin. Please welcome her.
Good afternoon, everyone. We all know that one of the industries greatly affected by the COVID-19 pandemic is the tourism industry. In fact, according to the DOT, in 2021, the Philippines recorded a decline of 88.95%, which translates to 1.4 million tourist arrivals in 2020 to 163,000 arrivals in 2021. Nonetheless, as the COVID-19 restrictions are slowly easing up, international borders are likewise being opened for foreign travelers. As of October 5, 2022, the Philippines has welcomed 1.7 million travelers since we opened our doors to international leisure travel in February this year. One of the businesses affected by the pandemic is Travel Asia, a travel agency in the Philippines which offers a tri-city package to ASEAN member states, Singapore, Malaysia, and Indonesia. However, due to the COVID-19 pandemic, its sales for the tri-city package has massively declined. Thus, immediately upon the lifting of the restrictions for international travel, Travel Asia extensively promoted its Tri-City package through its social media accounts and subsequently requested the DOT through the Tourism Promotions Board, or TPB, to help encourage Filipinos to avail of the said package. However, the DOT declined on the ground that RA 9593, or the Tourism Act, states that the TPB shall be responsible for marketing and promoting the Philippines domestically and internationally as a major global tourism destination, with the end in view of increasing tourist arrivals and tourism investment. Thus, the DOT argued that it should promote travel only within the Philippines and only within and in the Philippines, given that its tourism has declined by 88.95% in 2021. Travel Asia then filed a special civil action for mandamus to compel the DOT TPB to promote travel within ASEAN by Filipinos, on the ground that the ASEAN Tourism Agreement mandates its member states to intensify joint action to market and promote travel into and within ASEAN by supporting the Visit ASEAN campaign, which calls for thematic tour packages and attractions, and fostering cooperation among ASEAN national tourism organizations and tourism industry in marketing and promoting transnational tour packages, among others. Applying the 7-step process, it is my submission that the ASEAN legal rule can be applied to the domestic legal problem. The ASEAN Tourism Agreement has not been concurred in by the Senate but has been ratified by the President on May 5, 2003, was deposited on February 26, 2007, and is therefore considered as an executive agreement, making the Philippines bound by its provisions via transformation. Thus, the provisions of the ASEAN Tourism Agreement have been domesticated and is part of the Philippine legal system under Tier 3 and can be used as a source of Philippine legal rights or obligations. The effect of it is that it reinterprets and harmonizes RA 9593 with the ASEAN Tourism Agreement, particularly on provisions pertaining to the DOT-TPB's limited mandate to promote and develop Philippines' tourism industry, considering that there is no conflict between these two laws. It is thus my submission that Section 46 of RA 9593 should be read with Article 7 of the ASEAN Tourism Agreement. While Section 46 specifically mandates the TPB to promote the Philippines as a major tourism destination, applying the well-established rule of statutory construction that endeavors should be made to harmonize provisions of a law or two laws so that each shall be effective, harmonizing it with the international agreement will result to a reinterpretation of Section 46 to include in its mandate the binding obligation of the Philippines to promote travel within ASEAN countries as its secondary mandate, an obligation the Philippines undertook to comply with when it ratified the said agreement in pursuit of the need for ASEAN cooperation in making travel into and within ASEAN easier and more efficient. Thus, in this case, Article 7 of the ASEAN Tourism Agreement can be used as basis to compel the DOT-TPB to promote travel within ASEAN countries by Filipinos. Thank you and good afternoon.
Thank you very much, Attorney Marty. Where are you broadcasting from?
From Baguio, sir.
Baguio, okay. Sige. So we'll invite the 5 presenters, no, including Attorney Marty, here in front so that they can answer the questions. Okay, so first, for Attorney Iris, right? Yeah. Okay, so for Attorney Iris, you focused on the ASEAN Treaty on Mutual Legal Assistance in Criminal Matters. So we're looking at the provision that you quoted here, and it says, the parties shall render mutual legal assistance. Okay, that's all, no? It doesn't seem to specifically require every ASEAN member state to create a national database or criminal information. So how can we now interpret this Article 1 in order to support the relief that we want, which is to compel DOJ to create this national database?
Actually, Prof, the concern is valid. There is actually no explicit provision under the ASEAN MLAT for the creation of any such single criminal database. However, I was trying to interpret that the term, why this possible measure of mutual legal assistance, as to mean that the state parties should adopt all efficient, efficacious mechanisms to provide that request, to facilitate that request, in order to essentially cause the prosecution and proper investigation of criminal matters concerning other non-Filipino ASEAN nationals, Prof. Also, there is an enumeration under the ASEAN MLAT which provides the obligation on the part of the requested party to essentially locate certain witnesses or suspects in cases of the request, and also for facilitating securing documents and or other information from relevant individuals, Professor.
Okay, thank you. Thank you very much. Next will be Attorney Shar. Attorney Shar De Leon Yu, right? Sorry, Yu De Leon. Ayan, baliktad pala. Okay. So, Attorney Shar, you focused on the ASEAN Sectoral Mutual Recognition Arrangement for GMP inspection, right? And so you quoted Article 8, Paragraph 1. And if we look at the text of Article 8, Paragraph 1, it does seem to require a national agency to certify, right, when it is requested. But then I think what you want is for FDA, as our NDRA, to be obligated to make the request, right? So that does not seem to be in the agreement. The obligation to certify is there when requested, but the obligation to make the request is not there. So how can we interpret your ASEAN agreement provision to support the relief that we want?
Thank you, Professor, for the question. So while the mutual recognition arrangement does not specifically require the FDA to make a request, it is submitted that the FDA can still be compelled via a special civil action for mandamos. In this case, foreign drug manufacturers and drug importers have a clear legal right to at least be assessed by the FDA if they are indeed compliant with good manufacturing practices. However, through no fault of their own due to the pandemic, they are left with no recourse because the FDA has suspended the conduct of inspection. So now they just have to wait for the resumption of the inspection. There being no other plain, speedy, or adequate remedy for these foreign drug importers and foreign drug manufacturers, it is submitted that the ASEAN agreement be invoked to obtain the desired relief, which is to afford an alternative to direct inspection by the FDA and just make a request to the NDRA of the ASEAN member state to do the inspection on its behalf. After all, mandamos is equitable in its nature and its issuance is generally controlled by equitable principles. So the grant of the writ of mandamos, in addition, also lies with the sound discretion of the court. And in this case, I think it can be justified.
Okay.
Thank you.
Thank you very much. Next would be Attorney Dwight, who is broadcasting from Zamboanga ba? Zamboanga. All right. Okay, Attorney Dwight. So you're invoking the ASEAN agreement on the ASEAN Food Security Reserve, right? If we read the text that you quoted, it just says that the parties or the governments of the ASEAN member states agree. That's all, no? They just agreed to create this ASEAN-wide regional food security reserve. However, the relief that we want is we want NFA to be authorized to create this national food reserve. So how can we interpret the term agree to mean that NFA is authorized to create this Philippine reserve?
Pursuant to the principle of pacta sunt servanda, the Philippines has the obligation to comply with its treaty obligations. The agreement on the ASEAN Food Security Reserve has the same level as statute in the hierarchy of the Philippine legal rules. Pursuant to said agreement, the NFA may be authorized to create the National Food Reserve in order for the Philippines to fulfill and comply with its treaty obligations.
Thank you. Thank you very much. Next would be Attorney Francis. All right. Kamusta ka, sir?
Okay naman po.
Ayaw ka man? May kababayan? So for Attorney Francis, you referred to the Philippine Dental Act, and also in your oral presentation, you mentioned the PRC Modernization Act, right, of year 2000. So I'm referring to that PRC Modernization Act, not to this statute. Doesn't the PRC Modernization Act provide for the grounds for revocation of a Philippine professional license granted to a foreigner? That's the first question. And second, if it does provide for the grounds, doesn't that statute conflict with this ASEAN MRA, which also seems to provide for grounds for revocation of the license?
Okay, thank you for those questions, sir. For the first question, the PRC Modernization Act provides for the grounds for revocation of the license of foreigners, especially under the reciprocity rule that foreigner was admitted to the practice of dentistry in the Philippines. However, that act does not provide for cases wherein the foreigner committed the malpractice in his home state. So there is a gap, sir. As for the second question, there's no conflict in view of that because the two laws, the Modernization Act and the MRA, are complementary. The MRA fills the gap in the Modernization Act and as well as in the Dental Act because the two Philippine statutes do not provide for the grounds whenever the foreigner committed the malpractice in his home state. Whereas the MRA specifically provides that in order for the foreigner to continue practicing here in the Philippines, he should have a good record in his home state. That is, he should not have been guilty of malpractice in his home state.
Okay, thank you very much.
Thank you,
sir. So for our last presenter for this batch, Attorney Marty from Baguio. Okay, so Attorney Marty, your case study is on the ASEAN Tourism Agreement, right? So let's look at the provisions which you reproduced here in your slide. So if we look at the provisions reproduced here in your slide, it talks about joint action. So it seems to impose on the member states the obligation to take joint action, right? Now, it seems that there is no obligation on the part of DOT. We want to compel them, right? It seems that there's no obligation on the part of DOT to take unilateral action, right? Joint action, yes, but it doesn't seem to require unilateral action. And second, if you read the provision, it seems that the forms of the joint action are specified, right? Member states shall intensify joint action by, and so there's an enumeration of the specific forms of the action. Visit ASEAN, cooperation. It does not seem to require a member state, in this case, that obligation is cascaded to DOT, doesn't seem to require the state to take other actions not listed in the agreement.
For the first question, the promotion of the DOT can, in my opinion, cannot be considered as a unilateral action, but in fact is an indispensable part of a joint action together with other ASEAN member states, who likewise obliged to comply with the provisions of the ASEAN Tourism Agreement upon ratification of the same. For the second question, a reading of Article 7 can readily reveal so that DOT can likewise perform actions which would promote and market travel into and within ASEAN, which is basically the purpose and main intent of the ASEAN Tourism Agreement, and therefore the other ASEAN member states can perform other functions in order to promote the same.
Okay, thank you very much. So it is now 1 minute before 3 o'clock, and we did say that we'll take a 15-minute break. So we'll take a pause here, and then, so we've completed the presentations of 15 presenters. Huh? Let's give them a big round of applause first. Okay, so congrats to the first 15 presenters. We'll take a 15-minute break, and then we will listen to the presentations by the last 10 presenters. Okay, so we'll see you in 15 minutes. Welcome back to the Junior Scholar Symposium on Public International Law. This event is organized by the UP College of Law and supported by the Philippine Judicial Academy, the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Association of Law Schools, and the Philippine Society of International Law. Yesterday, we had presentations by our LEAP Fellows and our J.D. students. Today, we're having the presentations by our UP LL.M students. The aim of their case studies is to show that international law, as well as ASEAN law, which is a kind of international law, can be applied in Philippine cases before Philippine courts and executive agencies. So we'll now proceed to the last 10 UP LL.M student presenters. I will now invite, for her online presentation, Attorney Mejiliano.
Good afternoon. May I proceed, Prof?
Please.
Okay. Good afternoon, Prof. Good afternoon, colleagues. I am here to present to you my case study on the ASEAN Agreement on Movement of Natural Persons as basis to authorize a non-Filipino ASEAN business people to stay visa-free up to 11 months. So the case study, the facts of my case study are the following. Somchai Aromdi, a businessman from Thailand, intends to invest $30,000 in a publicly listed company in the Philippines and put up a Thai restaurant in Manila. Aromdi, with his family, needs to stay in the Philippines in order to put things in order, to stay in the country for at least 11 months. But he is thinking twice about investing in the country due to the visa and investment requirements and prefers to invest in Vietnam, which has an investor-friendly visa guidelines. So the Philippine problem that I wish to address in my paper is the strict requirements in granting business visa over foreign nationalities, including non-Filipino ASEAN business people. And the relief that is being sought here is to authorize a non-Filipino ASEAN business person to stay visa-free up to 11 months. According to my research, the Philippine rules which are applicable in my case study is the Book 5 of the Omnibus Investment Code, or the Executive Order number 226. Basically, it's about the SIRV program, which requires, it is a special investment visitor residence program, which provides that investors to remit at least $75,000 in the Philippines, and the said amount can only be invested in limited favorable economic activities. However, ASEAN Agreement on the Movement of Natural Persons, which Philippines is a signatory, it was entered into last November 19, 2013 in Phnom Penh, Cambodia, and the same was ratified by our former President Benigno Aquino III last May 13, 2016. However, it was not ratified by the Senate. Hence, it falls under the third tier, under the hierarchy of Philippine legal rules. So, the ASEAN Agreement on Movement of Natural Persons, actually, it desires to eliminate substantially all restrictions in temporary cross-border movement of natural persons involved in provision of trade in goods, trade in services, and investments. As to the question if there is a conflict between the SIRV program and the ASEAN Agreement on Movement of Natural Persons, my answer is yes. And how do I think this will, how do I wish to resolve this conflict? I believe that the canon of statutory construction and lex specialis derogati generali and lex posterior derogati priori, which means a legal rule arising after a conflicting legal rule prevails over the earlier rule to the extent of the conflict. Applying the 7-step process, it is my submission that ASEAN Agreement on Movement of Natural Person has been domesticated. Hence, it can be used as a basis to authorize a non-Filipino business people to stay visa-free up to a limited duration of 11 months. Thank you. Also, I would like to present our next speaker, Attorney Kathleen Mila.
Good afternoon, Professor. Good afternoon, classmates. So the problem that I wish to address is that transnational human traffickers cannot be extradited to Singapore. The relevant hypothetical facts of my case is Patty Kwon Lee, a 15-year-old Singaporean student from a below-middle-class family, traveled to the Philippines with her football trainer Andrew Lai Gomez for a summer training in Manila. After her arrival in the Philippines, Patty's family could no longer contact her nor Andrew. After almost a week without hearing from Patty, the police officers in Singapore informed Patty's family that they have discovered some nude photos of Patty in the dark web. Patty's family filed a criminal complaint against Andrew, and they believe that he is still staying in the Philippines. Singapore's foreign diplomat requested the Philippine Secretary of Foreign Affairs for the extradition of Andrew. However, upon forwarding the documents and request to the Secretary of Justice, the latter declared that the request cannot proceed because it lacked the requirement of an existing extradition treaty under the Presidential Decree number 1069 or the Philippine Extradition Law. Under PD 1069 Section 4, any foreign state or government with which the Republic of the Philippines has entered into extradition treaty or convention only when the relevant treaty or convention remains in force may request for the extradition of any accused who is or suspected of being in the territorial jurisdiction of the Philippines. In the given hypothetical case, since the Philippines has no extradition treaty with Singapore, we are not able to extradite Andrew. If we will to apply the ASEAN Convention Against Trafficking in Persons, especially women and children, particularly Article 19.2, if a party that makes extradition conditional on the existence of a treaty received a request for extradition from another party with which it has no extradition treaty, it may consider this convention as the legal basis for extradition in respect of any offense established in accordance with Article 5 of this convention. I believe that if we are to apply this ASEAN convention, we can seek the relief that the Patty's family is seeking. Given that the ASEAN convention has been signed on November 21, 2015, and then the ratification was on January 24, 2017. Unfortunately, it was not concurred by the Senate. We won't be able to have the relief that is being sought. So, if we are to apply the said ASEAN Convention, it will surely fill the gap on the problem that we are about to resolve. Thank you. Our next presenter will be Attorney Izaris Perez Mendoza via online.
Good day, everyone. I'm Izaris Perez Mendoza, and for my case study, please allow me to give you a hypothetical. Manila X is a hypothetical primary tourism enterprise engaged in slum tourism. It takes tourists on a commercialized interactive walking tour through the impoverished informal settlements in Manila. So these are places like Baseco, Payatas, Smoky Mountain, and even the homes along the Riles. Slum tourism, or sometimes called reality tourism, is a form of tourism that has poverty as its main attraction. Our hypothetical tour operator, Manila X, has been granted by the City of Manila and Quezon City licenses or permits to operate its business because it has complied with all the financial and documentary requirements, and it has also been accredited by the Department of Tourism. Although Manila X reasons that slum tourism is a tool for poverty alleviation through community involvement and social awareness, evidence suggests that slum tourism leads to the exploitation of host communities. Exploitation is twofold. First, socially, in that it is extremely voyeuristic and it reinforces existing socio-economic disparities. It has been said that host communities and slum tours are reduced to attractions in a social zoo. Secondly, there is also economic exploitation, in that there is limited evidence that the host communities get sufficient economic returns. Truth is, the distribution of profits favor tour operators and not the main attraction, which is the host slum community. We cannot turn a blind eye to the socio-economic exploitation perpetuated by Manila X's slum tours. Thus, the relief that we are seeking is this: that the DOT accreditation and LGU operating permits of Manila X be declared invalid. There is, however, a gap in our legal system as regards slum tours. It is not mentioned, much less is it regulated in any of our laws. The closest applicable Philippine rule is the IRR of RA 9593 or the Tourism Act. Section 122 on accreditation states that the department shall notify the concerned LGU when a tourism enterprise in their locality has failed to obtain or loses its accreditation. The LGU shall issue the necessary closure order should the tourism enterprise fail to rectify its deficiencies despite being accorded a reasonable period to comply with the standards. Currently, however, the requirements for accreditation and LGU operating permits do not involve safeguards against socio-economic exploitation. Nevertheless, the invalidity of Manila X's DOT accreditation and LGU operating permits can still be declared. How do we do this? By invoking the ASEAN Tourism Agreement, or the ATA. Please note that the Philippines signed the ATA in 2001 and ratified it in 2003. It is therefore very much on the same level as a Philippine executive regulation, domestic procedural rule, and local ordinance. Article 5 of the ATA deals with the subject of quality tourism. Paragraph 6 thereof clearly states that member states shall ensure quality tourism by taking stern measures to prevent tourism-related abuse and exploitation of people, particularly women and children. Socio-economic exploitation is covered by this provision. The study therefore proposes that the ATA can effectively fill the gap of our Philippine legal system as, by signing and ratifying it, the government took on the legal obligation to prevent the socio-economic exploitation perpetuated by slum tours. Definitely, Article 5, Paragraph 6 thereof can be used as a legal basis for any stern measure to be meted out to Manila X. This includes the relief that we are seeking in this instance, and that is to declare invalid Manila X's DOT accreditation and LGU operating permit for engaging in slum tourism. Again, I am Aizaris Perez Mendoza. Thank you for your time and attention.
Good afternoon, Professor Raj and my fellow students. Within the next few minutes, I will be attempting to show you how the ASEAN Comprehensive Investment Agreement may serve as a basis to authorize non-Philippine ASEAN investors to claim compensation for Marawi siege-related losses. In 2017, the Philippines' efforts to promote its image and reputation as a safe and secure investment destination was seriously damaged when violent extremist groups seized Marawi City. The Marawi siege has led to a massive crisis, displacing approximately 300,000 people, leaving many not only hopeless, but also without homes and property. For our discussion, let us assume that in 2016, a joint venture agribusiness between a Malaysian and a Singaporean company was set up in Marawi City. In their agreement, the Singaporean company contributed the JV's machineries, while the Malaysian company provided seeds and fertilizers. Sadly, both investments were destroyed during the Marawi siege. In April 2022, Republic Act 1169, or the Marawi Siege Victims Compensation Act, or the Marawi Act for short, was enacted. While the Marawi Act's IRR is still pending to date, I personally find the law laudable on two counts. First, the law helps address the needs of Marawi siege victims. And second, which is closer to our subject, the law shows to the international community that the Philippines is holding itself accountable to Marawi atrocities. However, an examination of the law reveals that it only limits compensation to 4 types of property losses, namely residential, cultural, commercial, and other properties. Applying this to our example, while the Singaporean company's investment is covered under other properties, the Malaysian company cannot claim under the law since it does not compensate the seeds and fertilizers that it lost. In addition, our constitution precludes the Malaysian company from suing the Philippines without its consent. In this regard, Section 1 of Act 3083 states that the Philippines consents and submits to be sued upon any moneyed claim involving liability arising from contract. Accordingly, we need to find a contract that serves as the state's consent to be sued given the limitations of Marawi Act. The ASEAN Comprehensive Investment Agreement, or ACIA, may serve as a legal basis to establish such consent. ACIA, which is a conventional PIL rule, entered into force on March 29, 2012. The Philippines deposited signed ACIA on February 26, 2009, and deposited its instrument of ratification on October 26, 2009. While the Philippine Senate has apparently not given its concurrence, ACIA has been domesticated via transformation. ACIA is binding upon the Philippines as an executive regulation, or Tier 3 in the hierarchy of Philippine legal system, following then President GMA's ratification on August 6, 2009. In its ratification, the Philippines recognized that ACIA enhances the protection of investment, thereby improving investors' confidence to invest within ASEAN. Accordingly, ACIA may be characterized as the Philippines' private and commercial agreement establishing the consent required under Act 3083. Under Article 12 of ACIA, each member state shall accord to investors of any other member state which suffered losses due to armed conflict non-discriminatory treatment with respect to restitution, compensation, or other valuable consideration. ACIA also requires the Philippines to take measures to ensure the protection and security of covered investments. Given ACIA's nature as a binding economic agreement, the Philippines is obligated to comply with these commitments. Applying ACIA to Marawi siege-related losses, the Philippines must implement non-discriminatory treatment when compensating non-Philippine ASEAN investors. However, Marawi Act has limited compensation to 4 types of property losses only, resulting to the discrimination of other investments similar to the Malaysian company. Thus, ACIA may fill the gap and authorize the Malaysian company to claim compensation from the Philippines based on ACIA's non-discriminatory rule. I submit that non-Philippine Philippine investors from ASEAN who are excluded from the Marawi Act's coverage may rely and invoke ACIA to cover such gap and authorize them to claim compensation for Marawi siege-related losses. Simply put, ACIA provides non-Philippine ACIA investors with alternative legal basis to claim compensation for Marawi siege-related losses. Thank you for listening. Let us welcome our next presenter, Attorney Cherry Kanda Melodias.
Good afternoon, Prof. Raj. Good afternoon, classmates. I offer my presentation to all government employees out there who are required to get travel authority in case they want to travel abroad, even on personal time. So, Miss Marga is a teacher. She lives in Davao City, and she intends to stay in Singapore for the Christmas break. And then she learns that she needs to present a travel authority at the immigration official, to the immigration official before she can board the plane. She was shocked because she didn't know, and she learned that it takes at least 2 weeks to process the travel authority. So she she came to me asking for asking on how to solve her problem. So I told her that, okay, let's file for declaratory relief to declare Section 6 of the Memorandum Circular of the Office of the President, which states that no government official or employee shall be allowed to depart for any travel abroad, even if such travel is for purely personal or private purpose, without cost from the government, unless such official or employee has obtained the travel authorization from his or her agency. This is Section 6, Office of the President, Memorandum Circular dated 22 November 2017. The international rule applicable in this case is the ASEAN Tourism Agreement, which aims to cooperate in facilitating travel into and within ASEAN. This is Article 1, Item 1. And to achieve the objectives of the ASEAN Tourism Agreement, member states agreed to facilitate travel within and into ASEAN by extending visa exemption arrangement for national of ASEAN member states traveling within the region, and easing the process of issuance of travel documents and progressively reducing all travel barriers. This is Item 6, Article 2. The domestication of ASEAN Tourism Agreement was made as follows. The ASEAN Tourism Agreement was signed on November 4, 2003, ratified by the President on June 5, 2003, and the instrument of ratification was deposited on 10 June 2003. The ATA then entered into force on 26 February 2007. Under Philippine rules, the ASEAN Tourism Agreement is an international agreement signed by the President. Under the Philippine Constitution, it is recognized as an executive agreement that does not require concurrence by the Senate to be binding. The ASEAN Tourism Agreement is an international agreement that does not amend existing statutes. It reinforces our domestic laws on respect for human rights, particularly the right to travel, which is limited only by law. There is no law that prohibits government employees from traveling abroad just because they are government employees. None of the Philippine laws restrict the right to travel. Thus, MC 35 effectively restricts the personal travel abroad of government employees by requiring the presentation of a travel authority prior to boarding. This violates the Republic's commitment to ease travel restrictions and to reduce travel barriers among and within the ASEAN region. Thus, Section 6 of Memorandum Circular 35 of the Office of the President requiring authority to travel for personal trips abroad of government employees should be declared invalid.
Thank you very much, Attorney Cherry. So, wait. So, Attorney Mika, no? Attorney Mika, is she here? She said she was, she's online. She said she was on her way here. So, is she online? Na-disconnect. Ah, sige. So, wala si Attorney Mika. She might just show up, no? She might walk in. So, si Attorney, sinong next? After si Attorney Kath. So, for Attorney Kath, the question for you is, so you're using the ASEAN Convention Against Trafficking in Persons as the extradition agreement, right? Because there's an extradition provision there. Can a non-ASEAN state use the ASEAN agreement as basis to request extradition?
As per my reading in the ASEAN Convention Against Trafficking in Persons, especially when children, sir, this is only applicable to ASEAN members.
Thank you. So they won't be able to use this ASEAN agreement. It's for ASEAN member states only. Okay. Thank you. And so who's next? Si Alex, no? Alex?
Yes, sir.
Tama?
Ay, may isa pa, sir. Ay, yung si Aiza.
Wala. Is she here? No, she's not, no? So Alex, ikaw na.
Ako na talaga.
You can take her time also. So 10 minutes for you if you want. Okay, so this is it's a new statute, right? RA 11
Yes, sir.
696. Very interesting, no? Marawi Siege Victims Compensation Act. And I'm focusing on section 14, which you reproduced here.
Yes, sir.
And it says other properties. Okay, so other properties. So my first question would be, can you please clarify whether we can use this section 14 referring to other properties to authorize compensation for seeds? That's the first question. And then second, I was listening to your presentation and then you did say that there's a gap, right? There's a gap in Philippine law. Would you agree that there is also seemingly a conflict? So there's a gap in one area of Philippine law but there also seems to be a conflict. If we interpret RA 11696 to be a restrictive list, right? RA 11696, a statute, appears to limit the types of property losses that will be covered, that will be compensated. So only those. You said 4, no? So if we interpret AKIA to authorize compensation for a 5th type of property loss, wouldn't you say there's a conflict between the statute and the executive agreement? And if there's a conflict, which will prevail?
Sir, to your first question, I will take the position that the definition under the law of other properties will not be enough to cover seeds and the fertilizers. Under the law, the definition of other properties is only limited to appliances, jewelries, machineries, new rice mills, and other equipment of value. So based on the definition, I'm taking the position that a seed and a fertilizer, it will be a stretch to cover seeds and fertilizer. Now to your second question, which is the more difficult one, I would still maintain, sir, that there's no conflict, primarily because I recall the basic principles on statutory construction, where if as much as possible, it must be endeavored that to harmonize the provisions of the law, and so that each law will be valid. And number 2, RA 11696 does not expressly state that these are the only limited. In fact, sir, in the declaration of policy, the law even recognizes that this is an effort for them to compensate losses during the Marawi siege. And third, sir, so even if there is an apparent conflict, by rule should be harmonized, and I'd like to take the position that it can be harmonized. 1169 and AKIA can be harmonized together, because whatever compensation 11696 cannot provide, we can use as a basis Article 12 of AKIA. In fact, even Article 11, which says that the state must protect and secure investments. So on the basis of those two, it can stand by themselves together.
Okay, thank you. Thank you very much, Attorney Alex. So for our last presenter for this group, Attorney Cherry, who wants to travel.
Always traveling.
So you focused on the ASEAN Tourism Agreement, right?
Yes, Prof.
If we look at the provision, I don't think you quoted it verbatim, right? You paraphrased it.
No.
Is it? This is the language of
yes,
the
that is the
agreement.
language.
Okay.
By easing the process of issuance of travel documents, and that's progressively reducing all travel barriers.
Okay, yes, I'm focusing on progressively reducing all travel barriers, right?
Yes.
So when we say progressively, we don't mean immediately.
Yes.
So progressively over a period of time.
Yes.
So we sort of give some leeway to the state
Yes.
to progressively over time, gradually.
Yes, I agree.
Reduce all travel barriers, okay? So that's my first point. It seems that the obligation to reduce travel barriers is not something that should be, performed immediately. They have some leeway. That's my first question. And second, just looking at the text that you reproduced here, the agreement does not seem to expressly prohibit an ASEAN member state like the Philippines from requiring its government employees to obtain travel authority before they go abroad for personal reasons, right? So how can we now, this is my second question, how can we now interpret this seemingly broad wording of the agreement to obtain the relief that we want, which is a declaration that Section 6 is invalid?
Okay. We should see that the ATA took effect in 2007. So progressively, travel barriers, the issuance of travel documents, should be they should not anymore, there should be no more that many documents required for the travel. So what the Philippines did is was regressive in requiring its government employees authority to travel before they may be allowed to travel abroad. So my position is that requiring government employees authority to travel abroad is a violation of that specific provision that requires member states to progressively reduce travel barriers. Was that the only question?
The second one is, there's no, it doesn't say that,
governments,
prohibited from requiring travel authority.
Yes, governments are not prohibited from requiring their employees to get travel authority. But the Philippines committed to cooperate in facilitating travel into and within ASEAN. By requiring government employees travel authority, the Philippines is not facilitating travel into and within ASEAN because it restricts government employees from traveling. So this is a violation of its international commitment.
Okay, thank you very much, Attorney Cherry. Thank you. So we now move to our last set of presenters, the final 5. Okay. So I now invite Attorney Hannah Barriantes for her presentation.
Good afternoon, Professor. Good afternoon, my classmates in the master's class. Okay, the National Disaster Risk Reduction and Management Plan, or in short, the NDRRMP, has 4 priority areas: prevention and mitigation, preparedness, response, and rehabilitation. The Philippine Institute of Developmental Studies, in last December 2016, published a study, published last 2017. That's the last and only review of our NDRRMP, and it only tackles the impacts of implementation in the local sector or in local communities in the Philippines. Vis-a-vis, when we review ASEAN Agreement on Disaster Management and Emergency Response, it covers the 4 priority areas, but it also, we can see in Article 7.1, it mandates the parties, by using the operative word shall, to appropriate, establish, maintain, and periodically review the national disaster early warning arrangements. Particularly, going back to the previous statement, the only time that we had a review of NDRRMP on the national level is when the Philippine Institute of Developmental Studies published its review on 2016. In fact, this review is not even mandated to be periodic, but is just merely calendared on a basis of study. Like, for example, when one particular government sector wanted to conduct a research or investigation, but is not really mandated periodically under any law. The closest provision that we have on the review of our disaster risk management and reduction plan is found in RA 10121 under sections 24, section 6, and section 9. In section 6, it states the NDRRM sees authority to review the NDRRMF. So this is the funding of the NDRRMP. It also introduced the authority of the OCD, or the Office of the Civil Defense, to review the local implementation. But when it comes to the ASEAN rule, which was, or ADMER, which was ratified by the President last December 2022, 2006, and concurred by the Senate last September 14, 2009, there's no particular review or provision under RA 10121 regarding the review of the National Risk Disaster Management Program. The closest provision is Section 24, which only mandates the submission of the report upon the sunset, or this is a sunset provision of the particular law. So it states the National Council, through the OCD, shall submit to the Office of the President, the Senate, and the House of Representatives within the first quarter of the succeeding year an annual report relating to the progress of the implementation of NDRRMP. Thus, the problem: there is no responsible body to review the National Disaster Management Program. Here we see the study, or the particular paper aims to examine the filling of gaps when we adopt the particular ASEAN rule, or ADMER, on mandating the establishment or assigning an authorized body to review the National Disaster Risk Assessment System. Hence, this paper would focus on the study of having the Office of the President as the overarching executive body under statute, the overarching executive body in cases of an unclear statute, or in cases wherein we have gaps in a particular statute. We are exploring the particular, we're exploring special civil action, or at least the launching of a special civil action, or filing of a special civil action for this particular relief. That ends my presentation. I'm pleased to present Attorney Suzy Claire Silieza.
Good afternoon, everyone. The elimination of violence against women and children is one of the priority areas of work, not just of the Philippines, but also of ASEAN and the wider international community. We all know that the Philippines have placed several government mechanisms to address violence against women and children, including trafficking. We have the VAUSI law, the Anti-Trafficking in Persons Act, the Anti-Child Abuse Act, to name a few. But there remains an obvious problem that is often ignored in the Philippines. We do not have reliable national data set on VAUSI and trafficking. By illustration, if a policymaker wants to develop evidence-based policies and programs to further end VAUSI, or to simply know which communities need more government support and intervention, this task will be challenging, if not impossible. Why is that? Based on research, there appears to be no consistent administrative prevalence data and costing data on VAUSI and trafficking. At the national level, while there is an ASEAN regional guidelines on VAUG data and data collection use, our VAUSI-related data and trafficking data remain fragmented, incomplete, and unreliable. This is problematic because there is a global consensus that VAUSI cannot be effectively eliminated and prevented without reliable data. So my case study argues that the ASEAN Convention Against Trafficking in Persons, especially women and children, ACTIP, for brevity, creates 3 state obligations. First is the duty to investigate, and the second is the duty to punish, and the third is the duty to prevent and protect. And I further argue that the state obligation to prevent and protect is fundamentally tied to a member state duty to collect reliable data. In other words, an ASEAN state cannot comply with its duty to prevent and protect if it is remiss in its duty to collect data in accordance with international standards. To be sure, RA 9262 and RA 9208 task the Interagency Council to only formulate programs and projects to eliminate VAO based on their mandate. But there is no specific mandate to collect, consolidate, and disaggregate data on VAO-C and trafficking, which is why I argue that ACTIP may serve as legal basis to compel the PSA as the primary statistician of the Philippine government to collect VAO-C and trafficking data. The provisions clearly state, the party shall establish comprehensive policies, programs, and other measures to prevent and protect victims of trafficking in persons, especially women and children. The party shall also undertake measures such as research, information, mass media campaigns, and socio-economic activities to prevent and combat trafficking in persons. So, the premise of the case study is simple. An ASEAN member state has the duty to protect and prevent VAO-C and trafficking, which comes with it the duty to collect reliable data in accordance with ASEAN guidelines. Because, again, there is a consensus. VAO-C cannot be effectively eliminated and prevented without reliable data. And a member state cannot prevent something it cannot even accurately measure. So the question now is, can ACTIP be a basis to compel the PSA? The answer is yes. Since ACTIP was signed on November 21, 2015, and was ratified by the President on January 14, 2017, and the instrument of ratification was deposited on February 6, 2018, it came into force on March 8, 2017. And so there is a clear argument to make that ACTIP has been domesticated via transformation. And in the hierarchy of Philippine legal rules, it is treated as a binding executive agreement pursuant to Article 2, Section 2 of the Philippine Constitution. And since I argue it does not conflict with any existing domestic law, it can be a valid source of obligation because it merely fills a gap in our domestic laws and clarifies the duty of the Philippines to prevent and protect VAO-C and trafficking victims, which necessarily comes with it the duty to collect reliable data. Lastly, I chose PSA because clearly RA 10625 mandates the PSA to collect, compile, analyze, publish statistical information relating to the country's economic, social, demographic, and condition of the people. So clearly, if you read RA 10625 in relation to ACTIP, there is a duty on the part of PSA to consolidate and disaggregate data on VAO-C and trafficking. Thank you.
Good afternoon. Good afternoon, Professor Palacios. Good afternoon, classmates. So I am Rochelle Luboling Sanchez. I will be presenting to you my case study for today. The problem that I am to resolve is that DAR disallowed support services to non-Filipino ASEAN investor with AVA with ARBs. The hypothetical facts of my case are ABC Corporation, a non-Filipino investor, entered into a management contract, agribusiness venture agreement with the agrarian reform beneficiaries of a banana plantation in Davao. the Department of Agrarian Reform is giving support services to its ARBs. In this case, they are giving facilities to the agrarian reform beneficiaries. It includes giving support services to ARVs under AVA. But in this case, it excluded the ARBs with the AVA with ABC Corporation, a non-Filipino investor. All right. The international rule that I will invoke in this case is ASEAN Comprehensive Investment Agreement as basis to compel DAR to provide support services to a non-Filipino investor. The particular proviso of ASEA is Section 1 of Article 6 on Most Favored Nation treatment. It provides that each member state shall accord to investors of another member state treatment no less favorable than it accords in like circumstances to investors of any other member state or a non-member state with respect to admission, establishment, acquisition, expansion, management, conduct, operation, and sale or on other disposition of investment. ASEA is a treaty which was signed on February 26, 2009 in Cham, Thailand. It is an international agreement rule. It is binding in the Philippines as it is ratified by then President Gloria Macapagal Arroyo via an instrument of ratification on August 6, 2009. It is domesticated in the Philippines via transformation. Since it is ratified by our President, it is therefore an executive agreement. It is under the third tier in the hierarchy of the Philippine legal rules, being an executive agreement. In the Philippines, Section 37 of RA 6657 provides that the park shall ensure that the support services to farmer beneficiaries is given. ASEA will fill in the gap in RA 6657. There is no conflict between ASEA and RA 6657. There is no discrimination even if the said ARBs are into an agribusiness venture agreement with a non-Filipino ASEAN investor. Hence, ASEA can compel DAR to provide support services to a non-Filipino investor as we should accord all investors the same treatment. This is in keeping with the rule on pacta sunt servanda. Thank you. That ends my presentation. I will be presenting Judge Maria Luna Liena Lantexesaba will be presenting online.
Good afternoon, everyone. I am Maria Lunaliana G. Lantixesaba, and my case study is about the ASEAN Agreement on Electronic Commerce as a basis to authorize a non-Philippine ASEAN domestic market retailer to submit e-reports to BIR. The case involves a Thailand investor who partnered with a Livo company and opened a Roots Coffee branch in the Philippines. Since the Thailand investor is a non-resident and he needs to submit his annual tax income, the Thailand investor applied with BIR that it be allowed to issue e-receipts and transmit its daily sales report to BIR so that by the time it submits his income tax return, he only needs to electronically submit all the documents needed for determination of his tax liability. The request for submission of e-reports was denied by as the Thailand investor is not a covered taxpayer, to which the law mandates issuance of e-receipts and electronic submission of sales data to the Bureau. So the Thailand investor filed a petition for mandamus with the regional trial court and argues that although Section 237A of the NIRC as amended by RA 10963 of the Train Law on Electronic Sales Reporting System, which provides that the Bureau shall require taxpayers engaged in the export of goods and services, taxpayers under the jurisdiction of large taxpayer system service, to electronically report their sales data to the Bureau through the use of electronic point of sale system, the Philippines signed the ASEAN Agreement on Electronic Commerce, particularly Article 7, 4B provides that member states agree to facilitate cross-border e-commerce by working towards eliminating or minimizing barriers to the flow of information across borders. Although this provision on ASEAN Agreement on Electronic Commerce is a soft obligation, the same should be read in accordance with the object and purpose of the ASEAN Agreement on Electronic Commerce by applying Article 31 1 of the Vienna Convention on the Law of Treaties, which provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in accordance with the context in the light of the object and purpose, that is, to develop and intensify the use of e-commerce to drive inclusive growth and narrow development gaps in the ASEAN region. The Philippines is bound by the ASEAN Agreement on Electronic Commerce when the Philippines signed it through DTI Secretary Ramon Lopez on November 11, 2019, ratified by President Rodrigo Roa Duterte on November 18, 2020, and the instrument of ratification was deposited on December 28, 2020. This agreement is domesticated by transformation as an executive agreement, which in the hierarchy of the Philippine rules occupies the tier 3, which is of the same level as an executive regulation, a procedural rule, or a local ordinance. The ASEAN agreement fills a gap in the Philippine rules from domestic sources. Thus, the ASEAN agreement on electronic commerce may be invoked by an ASEAN domestic market retailer as basis to authorize him to issue e-receipts and submit e-reports to BIR, even if he is not a covered taxpayer enumerated in Article 237A of the NIRC as amended by the Train Law. I have good news, though. The problem of the silent investor may not be experienced by the other investors now, because as of the moment, the BIR is already beginning its digitalization. In fact, in July 2022, it started e-invoicing of the 100 largest taxpayers. It's one of the covered taxpayer. Per BIR's website, the implementation could start in January 2023. Although the electronic invoicing will, however, be gradually introduced. That concludes my presentation. I will now turn you over to the last presenter, Mr. Frank Akbay.
Hello, good afternoon, everyone. Imagine a taxpayer being imposed of penalties because of late filing of tax returns, not because of the usual reasons like complexity of financial transactions or difficulty in coming up with a tax return, but the mere fact that BIR does not authenticate and does not accept e-signatures on its tax returns. It is uncommon for Philippines to have companies that have very few authorized representatives. Foreign corporations have permanent establishments in the Philippines, usually have 1, 2, or 3 authorized representatives. And when these authorized signatories travel abroad during that statutory deadline, there is no choice but to accept or concede with the imposable penalty. This is not a big problem last year because the penalties for late filing of tax return is just 1,000 for every delayed tax returns. But everything changed. During this year, April of 2022, BIR issued RMC 43-2022, which provides for a graver consequence for delayed filing of tax return. It provides for an exception to the general rule. The general rule is that any deficiency taxes discovered during tax audits shall not be subjected to 25% surcharge. However, this exception provides that in the event that during the tax audit it is discovered that the tax return was filed beyond the prescribed period, the entire deficiency tax, income tax, VAT, DST, withholding tax, shall be subjected to 25% surcharge. And BIR usually assesses in millions of pesos. You multiply that by 25% surcharge, it results into a very obnoxious amount, an amount that could easily be avoided if BIR authenticates and accepts e-signatures. Now here comes ASEAN Agreement on Electronic Commerce. This was signed by our very own DTI Secretary on November 12, 2018. And under the Philippine hierarchy of legal rules, as it stands, it is an executive regulation that could very well fill in the gap of our domestic law. The domestic law I'm referring to is the Electronic Commerce Act of 2000. Where is it now? The Electronic Commerce Act of 2000, there is legal recognition of e-signatures. However, it failed to provide a specific manner of authentication. Thus, Currently, BIR cannot fully implement that law, and thus, it only allows e-signatures for its 4 BIR forms. And mind you, there are over 60 BIR forms. So there is indeed a gap that has to be filled. And this executive regulation, ASEAN Agreement on Electronic Commerce, specifically provides and mandates each member state to adopt a measure based on international norms, a measure of authentication, of authenticating electronic documents and signatures. And thus, it can fill that gap of the law. So, all in all, ASEAN Agreement on Electronic Commerce could be used as a basis to compel BIR to authenticate and accept e-signatures on its tax returns. Thank you.
Okay, thank you. That was the last presenter, and now it's time for them to answer our questions. So, who was the first one? Hannah? No, Attorney Hannah? Okay, so for Attorney Hannah, your topic is on the ASEAN Agreement on Disaster Management and Emergency Response. And you quoted Article 7.1, right? So if you look at Article 7.1, there's this phrase which reads, as appropriate. Now, my reading of that is it gives discretion to the ASEAN member states to determine whether review, right, periodical review, whether review is appropriate. Okay, so that's my first question. Does it give discretion to the ASEAN member state to determine whether any form of review is appropriate, meaning there is discretion to review but no duty to review? That's my first question. And the second question is, the ASEAN agreement does not specify which government agency will do the review. Okay, so if we want to compel the Office of the President through a civil action, right? Can the Office of the President then say, no, it's not OP which will do it, instead it will be the Office of Civil Defense or DND which will do the review, not us, so therefore the petition should be denied?
Prof, to address the first question, my position is because as appropriate succeeds the word shall, by statutory construction, it suggests something mandatory. Thus, my position is it shall be interpreted not as subjecting the review to be discretionary, but necessarily only subjects the review or suggests that the method or the manner of the review, the one that will be discretionary for the implementation of the particular review or the periodic review, but not necessarily reviewing per se, because it's being preceded by the word shall. For the second question, legally, of course, the Office of the President can always, these agencies are mere alter egos of the President. Hence, the President can always delegate its power to the cabinet or the agencies. However, of course, it will rest upon the wisdom of the Congress to review on the wisdom whether it is wise for the same maker of NDR or MP to be the same reviewer of the particular program. Nevertheless, legally, yes. My position is the Office of the President can delegate it. As to who the agency would be and can the Congress step into with that particular wisdom, it's also possible.
Okay, thank you very much, Attorney Hannah. Next would be Attorney Susie Claire Celieza. Okay, so this case study is focused on the ASEAN Convention Against Trafficking in Persons, right? And you quoted Article 11, Section 2, which says parties shall undertake measures to prevent and combat trafficking in persons. Now, I focus on the phrase such as, okay? Does the phrase such as mean that the terms research, information, and mass media campaigns are merely examples? Okay, so a state does not have to perform those things because they're merely illustrative. Okay? So really, there's no obligation to collect data for research or information. Second question is, doesn't the PSA Act. You talked about the PSA Act, right? It imposed a mandate on PSA to collect data on social, economic, and demographic data. Doesn't the PSA Act already require PSA to collect the VAUC data, meaning there's no need to invoke the ASEAN agreement? And third, if we interpret the ASEAN agreement, which is a mere executive agreement on the third tier, if we interpret the executive agreement to require the collection of VAUC data, won't this interpretation conflict with the Data Privacy Act, a statute which restricts the collection and processing of personal data?
For the first question, Prof. Raj, while I did not include Article 11, Section 1 in the slide, I did explain that Section 2, Article 11 should be read in connection with Article 11, Section 1 of ACTIP, which specifically states that the Philippines has the duty to prevent and protect victims of trafficking. Of course, the Philippines, it's my argument that the Philippines cannot do this without relying on reliable data or without any national data on VAUC and trafficking. For the second question, I believe that the PSA is not collecting data precisely because it assumes that it has no mandate. And in fact, even if you look at the website, it doesn't have any data on VAUC, at least aggregated and consolidated data. Rightly so, because the RA 10625 is silent on that, which is why I argue that RA 10625 should be read in connection with ACTIP, which specifically mandates Philippines to prevent and protect victims of trafficking and VAUC. For the third question, I believe that the collection and consolidation of administrative data, prevalence data, costing data on VAUC won't necessarily violate data privacy because these data do not require the disclosure of personal information. But even if it did, there's still a mechanism that would comply, or the Philippines or the PSA can still put in place mechanism that would ensure compliance with data privacy, redaction of names, for example, or getting the consent of those people who would like to volunteer their information, etc.
Okay, thank you, Attorney Suzy. The next one is for Judge Rich. Okay.
Good afternoon, sir.
Judge Rich came from the DAR, right?
Yes.
So you're very familiar with agrarian reform beneficiaries. And Judge Rich, in her case study, focused on RA 6657. What's the short title of that law?
Comprehensive Agrarian Reform Law.
Okay, Carl, na? Okay, so the provision of Carl, which you quoted, Section 637, seems to limit the provision of support services to farmer beneficiaries only, right? That seems to be the limitation.
Yes.
And then in your case study, you also said that there's a gap, right? But would you not agree with me that there seems to be a conflict if we interpret the ASEAN Comprehensive Agreement to mean that PARC should extend support services to foreigners, also ASEAN citizens, ASEAN investors? Okay, so wouldn't there be a conflict? And if there's a conflict, which provision do you think will prevail? The statute, Carl, or the executive agreement, AKIA?
All right. First, it is my argument, Prof, that there is no conflict between the Philippine rule and the international rule, AKIA. And RA 6657, under RA 6657, I know there's a specific administrative order in DAR which states that agrarian reform beneficiaries could enter into an agribusiness venture agreement with a corporation or an individual. Well, it does not specifically state therein that they could enter into a foreign corporation under our ASEAN rules, under ASEAN rules on ASEA or ASEAN Comprehensive Investment Agreement. And the ratification of that of the ASEA, it follows that the Philippines, the agrarian reform beneficiaries could enter into an agribusiness venture agreement with a foreign corporation. And so there is no conflict. While it's true that the RA Section 37 of RA 6657 specifically provides only farmer beneficiaries, it follows that when you give support services to agrarian reform beneficiaries, if there's a management contract, because there are different types of AVA in the administrative order, and one of them is the management contract. So if there's a management contract, the DAR should not discriminate whether or not these farmer beneficiaries have a management contract or AVA with this foreign corporation.
So no conflict, no? No conflict.
No conflict, sir,
So-
but it will fill in the gap.
Okay, fill the gap. Now, hypothetically,
Yes.
what if there was a conflict? What if there's a conflict between Carl and Akia as we interpret it? Which rule do you think will prevail? Assuming, no? You say there's no conflict, but assuming there's a conflict, which rule do you think will prevail? The statute on the second level, or Akia, which is a mere executive agreement?
If there is a conflict, as is under pacta sunt servanda, and since it is our under statutory construction, we have to harmonize our laws so that both laws will stand valid. So if we are to harmonize them, of course, at first we have to harmonize them before we rule that they are in conflict.
Okay, sige. Thank you. Thank you. So next is Judge Saba. From where are you now? Cagayan de Oro? Are you in Cagayan de Oro?
Yes, Prof. I'm from Cagayan de Oro.
Mayong hapon dira sa imo.
Mayong hapon, Prof.
Okay, so Judge Leyna, your case study focuses on the ASEAN Agreement on Electronic Commerce. And if we look at the provision that you quoted, Article 7.4b, it refers to the facilitation of cross-border e-commerce, right? And for that purpose of facilitation, work towards eliminating or minimizing barriers. So number one, it seems that there's no urgent obligation. No? Work towards, it's a bit, meaning take your time, right? So maybe we don't, maybe we can't, how do you say this? Maybe a taxpayer can't say, oh, I'm already authorized to submit my e-report, because anyway, the obligation of the Philippines is to, work towards eliminating barriers. Okay, that's the first one. And then second, it seems to refer to e-commerce, no? Facilitation of cross-border e-commerce. I was trying to understand the facts of the case study that you presented, and from my understanding, they don't seem to involve cross-border e-commerce. Instead, they seem to pertain to domestic transactions only. Is that correct?
Yes, okay, I'll answer the question. Thank you very much, Prof. To answer the first question, yes, the ASEAN Agreement on Electronic Commerce imposes a soft obligation. The wording is too general, information. So as a taxpayer, in relation to the case study, the filing investor needs to submit reports to the BIR. That is his annual tax report. So one of the information that he needs to submit to BIR is the daily sales report to support his tax exemption or to support his claim for the computation of his tax liability. And as this filing investor in this case study is not only engaged in this coffee business, but he has also other related enterprises or other businesses. And he, as a taxpayer, he wants to pay less. So he will be asking for tax credits and privileges as to his other investments. So in order to for him to be able to to pay the right tax, so he has to submit all the necessary informations needed electronically. So my position is this law, although this is to general soft obligation, it can still be used by the ASEAN investor, also applying the Vienna Convention on the law of treaties, on the interpretation of the treaty. The intention of the e-commerce is to facilitate cross-border e-commerce transaction, but also to create an environment of trust and confidence among in the use of e-commerce in the ASEAN region, and to intensify the use of e-commerce and drive inclusive growth and narrow development gaps in the ASEAN region. To answer the second question, yes, it is. This is a domestic transaction. However, this ASEAN investor, as again, is not only engaged in this transaction, but he has other businesses, and in order for him to pay the tax, the proper tax for the government, also to prevent any tax fraud and tax evasion, he has to transmit all informations needed, including rulings in Thailand, whether if this investor is also claiming for tax exemptions, because the Philippines is also the Philippines and Thailand sign a double taxation agreement. So these informations, as a general term, these informations are needed, including these e-reports to the BIR.
Okay, thank you very much, Judge Lena. You sound like a CTA justice. Okay, for our last presenter, so we'll ask you a question, then Mika is already here. So after you answer the question, we'll ask Mika to answer the question for her. No? So for Frank, so Attorney Frank, you want to use the same agreement, no? The ASEAN Agreement on Economic Commerce. But if you look at Article 7, Paragraph 2, Subparagraph B, there's this phrase which is as soon as practicable, right? For me, that's a key phrase. It seems to soften the obligation. Does this phrase not give the ASEAN state the discretion as to when to implement this e-signature system?
Thank you, Prof, for that question. First, I submit that there is a use of the word shall, which makes the entire provision mandatory. And I submit that the use of the word as soon as practicable, it is only there to for the consideration that each member state has difference in authentication technology, but it does not in any manner derogate that provision into something that is permissive. And also, in the words of Attorney Greg, it is high intensity mandate, and also it should be interpreted in light of the current situation in the Philippines. There is a change in BIR regulatory requirements, and it would be unjust for BIR to impose a very expensive consequence to a problem, but does not effort to resolve it by authenticating and accepting e-signatures in its tax returns.
Okay, thank you very much, Attorney Frank. So that's the end of the presentations, but we have the question for Attorney Mika. So earlier, Attorney Mika was traveling, but now she's here, so she can answer the questions in person, right? So can we flash your slide? Okay. So the ASEAN Agreement on Movement of Natural Persons,
Yes,
right? And you were saying a business person can stay in the Philippines for up to 11 months without a visa, right? No visa, okay?
Yes.
Now, if we look at the provision of the ASEAN Agreement, Article 2, Paragraph 1,
Article 4 and
Article 4, no? Article 4, grant of temporary entry or stay.
Yes.
So it does not seem to say that when an ASEAN state will grant temporary entry and stay, that the ASEAN member state can no longer require a visa, right? So that's my first question. Doesn't seem to authorize the relief that we want. And second, I was looking at, also it's the Omnibus Investments Code, right? So Omnibus Investments Code would be an executive order issued by the then Philippine President Aquino at the time when she had lawmaking powers. So it would have the same force as a statute. If there's a conflict between the Omnibus Investments Code and the ASEAN Agreement, which is a mere executive agreement, which would prevail? Wouldn't the statute, wouldn't OIC prevail because of the principle of lex superior?
Thank you, Prof, for your input. For the first question, I would like to address the first question. I submit, Prof, that it's not provided that ASEAN members can stay visa-free. However, please allow me to revise, but I think it would be more appropriate if I just, instead of visa-free, I would just amend it to like a special visa privilege. Yeah, so that's my input, sir, for the first question. And as to the second question, sir, it is still my, I still submit, sir, that because of doctrine of harmonious construction and lex posterior derogati priori, sir, that the conflict can be still resolved. Because it is really my submission that the AAMNP has already been domesticated. Hence, the ASEAN business, non-Filipino ASEAN business people must have a special privilege here in the Philippines for business purposes.
Okay.
Thank you.
And so the ASEAN agreement will fill a gap in the Omnibus Investments Code, or it will, what will it do? It will conflict with the Omnibus Investments Code?
I think it will feel, if there is a conflict, and then it can be resolved, sir, based on the two doctrines that I have mentioned, sir. You also can fill a gap, but my submission is it has already been domesticated.
Yeah. Okay, thank you
Thank
very
you.
much. So we have come to the end of our Junior Scholar Symposium. Let's, yes, congratulations to everyone. You seem very relieved. I know you worked long and hard, and some of you lost many nights of sleep, right? They were bothering their spouse. Hey, help me with my research. Okay, so congratulations for your excellent presentations. I look forward to your short paper regarding this. It won't be hard because if you answer the Google form for the outline, that will guide you really for the paper, no? And so the aim for the case study is to show that rules of international law, including ASEAN law, can be used in Philippine cases. My personal aim is to share with you the skill that you can bring with you, apply in your practice, whether you're a private practitioner, government lawyer, or a judge, where you will apply ASEAN rules in your Philippine cases, right? And so hopefully I have also demystified ASEAN law and international law to you, you know. So don't be afraid to read ASEAN rules and international rules. Don't be scared to interpret them, use them in your argument, because really they're just Philippine rules, okay? So again, thank you very much for your contribution to Philippine legal scholarship. On behalf of the UP College of Law and also our event partners, the Philippine Judicial Academy, the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Association of Law Schools, and the Philippine Society of International Law. Thank you and see you at the next symposium.